Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia. We'll start our week with Judge McNally.
17?
Yep.
So what are you doing? Going to high school?
Yeah.
Where? Yeah, how's that going?
That's going pretty good.
Next year, Harvard? Huh?
Absolutely.
What are you gonna do?
Next year, after next year, we're going to do the Marine Corps. So
Well, congratulations. My dad was in the Marines. He'd love you. You're gonna plead to impeding traffic, right?
yes, sir.
To that charge, responsible or not responsible? I'm going to accept the plea, $150. I'll dismiss this fee. Good luck to you, young man.
Thank you, sir.
Have a great day.
Where's the clerk at?
Go right out the doors in the back and all the way down the end of the hall to your right. Kenneth Brown. 260-843-210. Is Kenneth Brown in here? How about Micah Taro
Sir.
Pervonen? You're gonna have to have a seat right there, sir.
Right
Okay?
here?
Yeah, right there at the table.
Thank you.
Where's Trenton at? You know where Trenton is?
Sure, so we right here.
Do they have a phone? Okay, I need you guys up here. Mike Otero Hervonen. Come on up, officer, please. Come on up. Your name? Come on up to the podium, sir. This is 06110. Good morning. Your name?
Morning, Judge. Officer Mouse.
Your name?
Me, Coachella.
I need you to, when there's an accident, I need to know that there was minor damage and no injuries. If I'm gonna give them impeding.
Yes.
Is that what the case was here?
Yes, sir.
Would you write that on there, please? And sir, you're going to plead to impeding traffic, but you're gonna be careful going forward, right?
Yes, sir.
All right, to that charge of impeding traffic, responsible or not responsible?
Possible.
All right, I'm going to accept your plea. I'm gonna assess fines and costs of $195. You can go down the hall and take care of that, and you're all set. Wish you well. Good
Thank you,
luck.
sir.
Thank you. Thanks. I met your child not long ago.
Oh, you got the little one.
Yes, yes.
Come see you.
Well, good. Glad to have him anytime. Kenneth Brown here, 267-843-210. Good morning. Your name?
Kenneth Brown, Your Honor.
So they're gonna plead it to prohibited parking. You have to keep that up though, right? You had that expired plate for 5 months, right?
Yes, sir.
To that charge, responsible or not responsible, prohibited parking. $85, you're all set. Cash, you're in the hall.
Thank
You're
you.
right, and the expired plate's dismissed. Good luck. Christopher Kent Blakeman. 260-648-948. Your name, sir?
Mr. Kenneth Blake.
Good morning to you. You are going to plead responsible to the charge of impeding traffic, correct? I don't have a traffic record on him, Heather. I'm gonna need one. Can you run that?
I sure can. Sorry about that, Judge. I just added him on Friday. My
That's
apologies.
okay. I just want to make sure he's got a clean record. You have a clean record?
Yes, sir.
I'm going to run it right now, and I will let you know it's running. Taking a second here.
Okay.
I don't know why it's so slow. Usually they come out super fast.
Time.
When we need it, it's taking forever.
That's okay.
Here it comes. All right, let's see what we got here. We have absolutely nothing on the record.
To the charge of impeding traffic, responsible or not responsible?
Responsible.
Please accept the $150. Failure to yield, dismissed. Good luck. Cashier into the hall to your right. Morning, Lieutenant.
Morning.
How you doing today?
No, good, thank you.
Good.
How are you?
Good?
Good.
Ready to go. Rip Monday morning, raring to go. Those emotions in your desk. I see Mr. Trozy. Grab him. Did you bring him?
Oh, no, I'll grab.
Juan He?
Yes.
Come on up here, sir. Good morning. 260-648-353. How you doing?
Good, thank you.
Your name? Right to the podium there.
Joaquin.
You got to go to that podium.
Yeah.
Speak into that microphone.
Joaquin.
Can you turn that toward you? No. The podium. It's a swivel podium. Just, it's a swivel. It swivels.
Oh, it's well.
No. Leave that. Let that. Yeah, now
Okay.
face it towards you. There you go. You're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that?
Okay.
All right, you got a clean record. 150 is your total. Cashier into the hall to your right, and I'm gonna go ahead and dismiss the speeding, and you are all set.
Thank you.
Best of luck. ABD Al-Kiram Samir Hamka. 26W843113. How you doing?
Good morning, how are you?
Your name?
Delaney, Micah.
So you got one hazardous action on there. You're gonna plead to impeding traffic. They're gonna dismiss the speed, right? Yes?
Yes.
Responsible or not responsible to that?
Responsible.
Please accepted. 160 is your total. Cashier into the hall to your right, and you're all set. Good luck.
Sorry, good question. Hazardous, what was that in the beginning? I didn't catch.
You got a hazardous action number from 25. You were involved in an accident. That's why I'm charging an extra $10. Okay? 160. Cashier into the hall. Thank you. Looks like a basketball player there. Did you play basketball?
Yes, sir.
Huh. What tall are you?
6'8".
Wow. In my dreams. Somebody here from Mr. Weltman, Weinberg, and Rice, Mr. Besk, or Mr. Beers, or somebody?
I didn't hear you, Honor.
Okay, let me pull those files out. Citibank and Capital One versus Trozine.
Good morning once again, everybody. It is TCF Live on this glorious Monday morning. Good to have you all with me. We'll keep an eye on Judge McNally, but he's off to a little bit of a slower start, so let's go check in Allegan County with Judge Skocelas.
Office and a charge of possession of cocaine at the casino. They also indicate he has a prior drug offense and is a fourth or subsequent habitual felon. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Sandifer for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He does qualify for a court-appointed attorney. We request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
It's a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are setting this for you within 2 weeks. Your probable cause conference is a week from Thursday, which is July 30th at 1 p.m. in this courtroom, District Courtroom A. Preliminary examination itself is the following Wednesday, August 5th at 9 a.m., also in this courtroom, District Courtroom A. Bail was set at warrant authorization at $1,500 cash or surety. Court file shows you posted a $1,500 surety bond. Bail will be continued in that amount with the condition you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will be with you at your next court appearance, which again is a week from Thursday at 1 o'clock in the afternoon. So you are free to hang up the court proceeding this morning. Okay?
Thank you, Ron.
File 261888 SD, People versus Matthew Lee Sherwood. Here this morning for arraignment charged through a citation issued by the Allegheny County Sheriff's Department on a charge of operating while intoxicated. Sarah Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Sherwood for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. He will be entering a plea of not guilty today and does qualify for a court-appointed attorney. We request this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
When or not guilty plea, set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you released from the Allegheny County Jail on a $500 PR bond. Bail will be continued in that amount with the condition you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. Your case to be set first for a pre-trial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will be with you at your next court appearance, which will be the pretrial conference. Date and time of that is going to be sent to you by the clerk's office in the mail. So you are free to hang out from the court proceeding this morning. Be expecting that in the mail, okay?
All right, thank you.
Have two files, both on Ronald Brian Stark. Both of these cases are based on the same citation that was issued by the Wayland City Police Department. These are on charges of operating an uninsured motor vehicle and operating a motor vehicle with plates that have been expired for more than a month. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Stark for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. Mr. Stark will be entering pleas of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
The charge of operating an uninsured motor vehicle will enter a not guilty plea. Set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail on this case at $1,000. Personal recognizance. Condition of bail is that you not operate this 2012 Chrysler until you obtain valid Michigan insurance on that vehicle. Case will be set first for a pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So on that case, an attorney from the Public Defender's Office will be with you at your pretrial conference. Date and time will be sent to you with the clerk's office in the mail. On the charge of operating a vehicle with expired plates, that is a civil infraction. And as a civil infraction, there's no chance that you'll be incarcerated as part of your sentence. So the Public Defender's Office will not be representing you on that case, which leaves you with two options, either to hire your own lawyer with your own money or to represent yourself. But at this point, I'm going to enter a denial for you on the civil infraction. This will also be set for a pretrial conference with the prosecutor's office. If not resolved, it'll be set for a formal hearing, also in this courtroom, District Courtroom A. Again, the dates and times of your next court appearances are going to be sent to you by the clerk's office in the mail. So you are free to hang up the court proceeding this morning. Be expecting those in the mail. Okay?
Okay, thank you.
261-867-FY, People versus Jared Anthony Turbort, here this morning for arraignment charged through a felony complaint issued by the Allegheny County Prosecutor's Office on a charge of possession of a dangerous weapon. They also indicate he is a third habitual felon. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Turbort for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He does qualify for a court-appointed attorney. We request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
This is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. Your probable cause conference is a week from Thursday, July 30th at 1 p.m. in this courtroom, District Courtroom A. Your preliminary examination itself is the following Wednesday, August 5th at 9 a.m., also in this courtroom, District Courtroom A. Bail was set at warrant authorization at $1,000, cash or surety. Court file shows you posted a $1,000 bond in cash. Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will be with you at your next court appearance, which again is a week from Thursday at 1 o'clock in the afternoon. So you are free to hang up the court proceeding this morning. Okay.
Thank you, Your Honor.
260-714 SM, People versus Evan Allen Wheeler. Here this morning for arraignment charged through a misdemeanor complaint issued by the Allegheny County Prosecutor's Office and a charge of assault and battery. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Wheeler for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. He will be entering a plea of not guilty and does qualify for a court-appointed attorney. We request this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Or not guilty plea, set this for a jury trial, indicate you're requesting an attorney at public expense. Bail was set at $500 personal recognizance and will be continued. Condition of bail is you have no contact with the Jameson Berg while the case is pending. Your case will be set first for a pre-trial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Public Defender's Office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will be with you at your pretrial conference. Date and time of that is going to be sent to you by our clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting that in the mail. Okay?
Okay, thank you.
Have two separate.
Morning once again, everybody. It is TCF Live on this glorious Monday. It is good to have you all here with me today. If you are new out there, welcome. Do feel free to say good morning to us in the chat. You'll find us to be a friendly folk here. I want to give a special shout out before we go to the next court to my cat, Ellie. I woke up this morning, quite honestly, feeling just a little bit stressed. Ellie sensed that, threw herself down at my feet, started rolling around on them, and then licked them clean. And by the time it was all done, I was laughing and mood fixed. They say that dogs are a man's best friend. This man's best friend is a cat. So thank you, Ellie. Okie dokie. Let's stay in Michigan. Let's go say good morning to Judge Oakley.
University of Michigan versus Alba.
Good morning, Your Honor. Pamela Anderson appearing on behalf of the defendant.
And nobody here from U of M?
Not that I'm aware of, Your Honor.
Highly unusual. This is a pretrial counsel. What do you want to do?
I move for a dismissal, Your Honor.
Dismissed.
Thank you.
You're welcome.
I will send in the dismissal.
Thank you. How
Have
about
a good-
LBNV versus Schaeffer?
Good morning, Your Honor. Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
And defendant failed to appear, counsel?
That is correct. We have not heard from him.
What's your pleasure?
We are asking for a default judgment in this matter.
Send it in.
Thank you, Your Honor. I'll have that sent over.
Thank you. Heather, the next one is 9 o'clock, Lizette versus LeBlanc.
Correct, Judge.
All right, who do we got? Who's here on that one?
I am.
Good morning, Your Honor. Attorney George Long for the plaintiff, P79687.
Good morning, Mr. Long. You've had a chance to talk to Ms. LeBlanc?
Yes, Your Honor.
All right, Ms. LeBlanc, today's the date and time set for pretrial. It's a chance for me to get some information about the file and hopefully get it on the calendar and move it toward the resolution. Where are we at, Mr. Long?
Your Honor, we believe that we're close to a resolution. We would like additional more time. We request an adjournment so that we can avoid the necessity of court.
Sure. August 25th, give you enough time?
Yes, Your Honor.
We'll just adjourn the pretrial till then. Carly, 9 o'clock still work?
9:15.
9:15 work, folks?
Yes, Your Honor.
Ms. LeBlanc?
Yes.
All right, any questions?
No.
Ms. LeBlanc, any questions?
No.
All right, have a nice day.
Thank you, Your Honor.
You're welcome. Anything else, Heather?
No, we're waiting for Mr. Dylan Clark to get out of the breakout room with another one of his 9 o'clocks, and then we'll be ready on 2.
All righty.
Alrighty, well, he takes a break. Let's move along. Where do we want to go? Let's go to Huron County, Judge Prill.
Time and day set for arraignment. Mr. Britt is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Rutkowski. Mr. Rooney, have you received a copy of the information that's been filed in this case? Have you and your client had the opportunity to review it? Do you waive the reading as well?
Yes, to all those questions, Your Honor.
And it appears there's a plea agreement. Is that correct? Mr. Britt, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Mr. Rutkowski, would you please state the terms of the plea offer on the record?
Yes, Your Honor. Mr. Britt would be pleading no contest to the sexually delinquent person notice that we filed. People, or the parties, I should say, agreed to stipulate a guideline range and sentencing guidelines of 12 to 20. Mr. Rooney had done some research as well as myself. It looks like the guidelines don't apply, but if they were to apply, we have agreed that it would be in the area of 12 to 20 months.
So it'd be count 2.
Yes, Your Honor.
All right. Mr. Rooney, is that your understanding of the plea offer?
It is.
Mr. Britt, is that your understanding of the plea offer?
Yes.
Do you wish to accept it?
Yes.
Are there any other terms to the plea offer that we've not covered on this record?
No.
Mr. Rooney?
I agree.
Mr. Rutkowski?
I agree.
Mr. Britt, are you on any term of probation or parole?
No.
Have you had sufficient time to speak to Mr. Rooney about this?
Yes.
Do you need any additional time to speak with him?
What's that?
Do you need any additional time to speak with him?
No.
Okay. Anything affecting your mind or brain making it difficult to make important decisions?
No.
You kind of delayed it. I want to make sure you understand everything that's going on here, sir. Anything affecting your mind or brain where you feel you cannot render very important decisions?
No.
You have a clear mind.
I think so.
Okay. You were charged in count 2 with sexually delinquent person. That is a felony, and there is a sex offender registry as well. How many years on the registry?
It's tier 1, 15.
15 years, sex offender registry. And the maximum sentence would be 1 day to life. You understand that?
Yeah.
Understanding that, then, Mr. Rooney, how does your client plead to the charge of sexually delinquent person on or about May 19 of this year in Hume Township?
He pleads no contest to potential civil liability.
Is that your plea, no contest, sir?
Yes.
All right.
We have no objection to that, Your Honor.
Thank you. Appreciate that. That is the proper basis to proceed. The court is in receipt of an advice of rights form. It's dated today and it has a signature on it. It appears to be Tom Britt. Did you sign that document, sir?
Yes, I did.
Now, before signing it, did you read it over?
No.
Did you go over it with Mr. Rooney?
Yes.
Do you understand the rights contained on the form?
Yes.
By pleading no contest, you're giving up those rights.
Yes.
Means you will not have a trial of any kind or have any opportunity whatsoever to contest your guilt. A no contest plea is tantamount to you admitting your guilt, and all that remains after today will be for you to be sentenced. Understand that? Yeah. If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice. You understand that? Yeah. Other than the terms of the plea offer outlined on the record, has anyone promised you anything like leniency to get you to plead no contest? No. You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Understand that? Yeah. Has anyone promised the court will be easy on you? Has anyone threatened you with this plea? No. Is this plea your own free choice? Yes. Court costs are due and payable at time of sentencing unless there's good cause shown. Do you understand that, sir? Yes. And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence. Understand that? And finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. Do you understand that, Mr. Britt? I didn't hear your answer. Yes. Okay, thank you. I just couldn't hear you. Any question regarding any of your rights? No. Any questions of Mr. Rooney? Apparently, we have People's Proposed Exhibit 1. Any objection to its admission, Mr. Rooney? Or is that Defendant's 1?
It's mine.
It's Defendant's 1. Mr. Rakowski, any objection?
No, Your Honor.
This would be Huron County Sheriff's Department Incident Report 26,350, 3577. Use as a factual basis, correct, Mr. Rooney? No objection. People accept Defendant's 1 for purposes of this plea. Mr. Rakowski, where any promises, threats, or inducements for this plea other than ones for this court?
No, Your Honor.
Mr. Rooney? No, Your Honor. Has the court complied with the court rule concerning pleas, Mr. Rakowski?
The court has.
Mr. Rooney? I agree. Mr. Britt, there's no agreement made by this court concerning the plea and what the final outcome. Is that accurate? Yes. Mr. Rooney? I agree. Mr. Rakowski?
I agree.
The court will accept the plea. It's done freely, it's voluntary and understanding. The court had the opportunity to review Defendant's Exhibit Number 1, which clearly establishes the elements of the offense beyond a reasonable doubt. Hence, the court will accept the plea and schedule sentencing for September 21st. Mr. Rooney.
Available.
Thank you. Sentencing September 21, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report be prepared, provided both counsel and the court at least 2 days from sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing with notice of probation. Mr. Britt must appear in the courtroom at time of sentencing. If there's any supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond set at $10,000, 10%. It's been posted. Mr. Rakowski, your position up.
We're not aware of any issues, so we would have no objection to continuing bond.
Thank you. Mr. Rooney?
I'm not aware of any issues. I really asked.
Bond will continue as previously said in this matter. September 21 will be the sentencing date. You're going to have to meet with the probation agent here, Mr. Britt, to schedule a time to meet with them. Also, the court is going to order, based upon the information contained within the report, that sex offender registry be done.
Your Honor, will I vote with Thursday?
Absolutely,
Thank you, sir.
absolutely. Anything else for the record, counsel?
No, Your Honor.
That'll conclude the procedures. Thank you. You off the record.
Alrighty, friends, let's go back to Judge McNally. Check back in with him.
Your name?
Charles Cage.
Where do you play do you play basketball?
I do.
Where?
In mid-Michigan, in Mount Pleasant.
At Central? That's-
It's the community college.
All right, well, good luck to you. You're gonna plead impeding, right?
Sir.
Responsible or not responsible? All right, I'm gonna accept your plea, 150, speeds dismissed. You got a clean record. You're all set. You go right down to the cashier and make your payment. Good luck.
Thank you so much.
Have a good day. Good luck. Gregory Spalding. 267-843-349. Good morning. Your name?
Gregory Spalding.
You're gonna plead to impeding traffic, right?
Yes, sir.
Responsible or not responsible to that? All right, I'll accept that plea, dismiss the speed. You got a clean record, 150, you're all set. Cashier into the hall to your right. Good luck. Joshua Edward Manolius, 26T648758. Which one do you have, Ms. Patillo?
Found and I just probation on, but it might be quick.
Okay. Your name?
Josh Noise.
How you doing? You're gonna plead to impeding?
Yeah.
Responsible or not responsible to that? What are you, did you just graduate?
Yeah, I'm now down at University Toledo in my second year.
What are you studying?
Pharmacy.
Good for you. 150 is your total. Study hard. Good luck.
Thank you, sir.
John, I need the Solomon night. Will. I need the Solomon
I
night.
have.
People again. Solomon Wesley Knighton, 24F 16369.
Good morning, Your Honor. DNF is guilty 82378 on behalf of Mr. Knight.
Mr. Knighton, your name. I'm sorry.
Solomon Wesley Knighton.
How we doing, Mr. Knighton?
Okay.
Nice of you to show up today. What's going on here, Ms. Patillo?
So, Your Honor, it looks like there was a payment of $65. He made that payment.
When?
You know,
I
around.
think it was last week, Thursday.
How'd you make the payment? Do we have proof of that, Heather?
He made a payment of 165 on Friday.
What else do I have to do with Mr. Knighton? I placed him on probation March 18 to 25 for 15 months.
The only thing I didn't look up that.
Call in, let's call in here. Let me just double check one thing. I will have you out of here in a minute, hopefully. Can you come in on Solomon Knighton, please? Thank you. Shady.
Yep.
These are. Ms. Oda, good morning on this fine Monday. Your name?
That's what I'm.
He paid his 165 the other day.
Yes, I did see that. I told him to have, everything else was done, it's only the money. I told him to have it paid by the end of June and it was running too close to when his case was to expire, so I issued the letter.
So we're gonna just,
Everything's done to close out his file now that it's been paid.
discharge him with improvement.
Thank you, Judge.
All right. Good luck to you. We're gonna discharge you with improvement and close your case. I don't wanna see you in here again, Mr. Knighton. Got it? Got it? Good luck. Thanks, Ms. Patillo. People against. Brittany Elizabeth Irvine, 26T648701. Good evening. Good. What's that?
I got stuck by a beat, so I'm like, oh, it's.
Oh, no. That's terrible. Your name?
Any Irvin?
You're gonna plead to impeding, right? Responsible or not responsible? All right, I'll accept the plea, dismiss the speed, 150. You're all set. Have a great day. Anaya. Against Jessica Lynn Anaya, 25R 514-118A, 24R 254-240.
Good morning, Judge and staff. John Roxanne, appearing on behalf of Jessica Lyons in my lap. Please identify yourself. Jessica Lyons.
All right, I took these pleas under 771. She pled, so let me just back it up here. I'm gonna need Madeline and you can call over there, what's hers?
Judge, she's still technically in violation, and I did speak with Madeline. I'm happy to have her come over because she'll confirm the fact that although it's been slow progress, Ms. Anaya has been making progress. She's not become the community service. It should have been done by this time. She's also gotten rid of the warrant out of Lincoln Park, which is on a drunk driving case.
So I had a disorderly that was reduced to 771.1 on 25R 254-240. She was in here on May the 21. She pled guilty to failure to pay her fines and costs as ordered, failure to attend her scheduled visit on May 11, and failed to clear all warrants by May 1. Then on the other file, 25R 514-118A, she was in here on a furnishing alcohol to minor, which I also took under 771.1, and she pled guilty to failure to complete 20 hours of community service. So on that date, back on June the 22nd, I said I'd set a sentencing date today at 8:30. And her community service hours she was supposed to have done was 20 hours. I first gave her until June the 1st of 26. So where are we with everything here? What is she doing?
Judge, what's happened is she has completed, well, go ahead, Ms. Raptis.
Your name?
Madam Rogers, probation.
I can't wait to hear. Tell me what's
Judge,
going
what's been happening is she has completed 24.5
on.
hours.
Provide proof of that to you?
She did.
Are you satisfied with that?
She still has 20.5 hours left to complete, that have been long overdue. But she has made some progress.
Judge, under the circumstances, I believe she's made significant progress. She's gotten rid of the warrant of Lincoln Park. Secondly, she's next going to be getting rid of the warrant out of 36th District Court. She is working.
She's got, hang on.
It's long overdue, Judge, but she is making progress.
You're very immature. You know that, Ms. Anaya? Very immature. How old are you?
I'm 36.
It's time to grow up.
I'm trying to get it out the way.
You're trying to what?
Get everything out the way. It's taking a little longer than expected.
Why? Tell me why. Get a little.
Don't drive.
Why don't you drive? You don't have a license?
No.
Do you ever have a license?
Yes.
You got it suspended or revoked?
Yes.
Which?
Suspended.
Why?
Was a drunk driving out of Lincoln Park at 2020, Judge, and she failed to address it. She owes another $500. She'll be dealing with that with Judge Clifton. She has another issue out of 36th District Court, but it is less than $120. She is making progress, Judge. She got a paycheck recently.
Remind me, do you have kids?
Yes,
sir. Yes, 3.
Are you married?
No.
Any of the fathers into their lives?
One.
Is it this?
Judge, it's a difficult situation, and although it doesn't look as good as it should, she has been working very hard. She has the support of her mother. I would hope that this.
Here's the problem. I cannot keep going on a 771 case longer than a year. I sentenced her May 15th of 25. Now it looks like on the, did I revoke that status? It looks like, Heather, and yeah, I did. And I sentenced her on the other case, on that case, March 19, to serve 20 more hours by June 1. And that's all I ordered. Then on the other case, on the Rockwood case, did I ever revoke that status?
I don't believe you.
On which one? They're both Rockwood cases, Judge. So that one would be that one ending in, is that the 240 or the 118?
Correct.
The 240?
Yeah.
Let me look at the,
Well, I only placed her on probation on that on March 19th.
I don't see anything revoked that I'm seeing on that one.
Can I ask you a question? Why, when I told you on May 21 to clear all your warrants, first you had until when I took the plea on May 21, after you failed to clear by May the 1, why didn't you go clear those warrants yet?
It's just been a transportation issue.
No.
A money issue. I don't have transportation to get to Detroit at 8 o'clock in the morning.
Well,
I could get there to the Lincoln Park one. And the other warrants is just for $294 traffic tickets, which I can't see online.
can you run that? My lien here is dated June the 15th. Will you make sure that warrant's cleared out of Lincoln Park?
Judge, I did verify that she just cleared that warrant on the 16th, last week.
16th of July.
Yes, at Lincoln Park. The Detroit warrants are still active. I looked those up. I was able to see them through my work.
Why do you procrastinate? How did you get to work? How did you get to Lincoln Park?
A friend of mine.
Why couldn't you have gotten a friend of yours to take you over there long before July 16th?
It was hard to get her to take me then.
Judge, there's no excuse, and please take into consideration, he brought up jail with the fact that she's made progress, albeit too slow, but nonetheless, she is making progress, that she does take this matter seriously.
Anything? Defense declare all warrants by sentencing date, I wrote down. I don't know why, I just feel like you
Judge.
need to proceed in life. How do I say this? With more promptness. Let me just put it that way. We don't get to procrastinate. Heather, give me a date in 3 weeks. I'm gonna adjourn this one last time. I'm gonna have this done. You're going to jail, okay? You're gonna clear your warrants. You're gonna take care of everything. You're gonna have your community service done. Again, if you don't, you're going to jail. Adjourn 3 more weeks. Last chance, ma'am.
3
Feel
weeks,
okay.
I'm sorry, Judge. 3 weeks you're not here. We could go to the 17th.
Adjourn August 17th at what time?
We could do 8:45.
Judge, I don't think she'll be unsuccessful, I think she'll be successful, but if she is not successful,
Tell her to bring her toothbrush and underwear
how much time in jail, Judge?
the whole time.
Okay,
Okay?
thank you, sir.
August 17th at 8:45. You better get it done. I'm writing down. Or jail if not completed. And you know what I'm gonna do? Just so I don't miss it myself, which I won't, I'm gonna make sure I highlight this. Gotta grow up. Just gotta grow up. Go down the hall, get your notices. We'll see you back here. Thank you.
Thank you, Judge.
Gotta grow up is good advice for everybody. Good morning once again, everybody. TCF Live on a Monday. Good to have you all with me. Let's head to Florida. Say good morning to Wade Mercer.
Yes, sir. Okay, so we have at least one, we may have 2 interpreter cases. My list has Aberlando Eco Chubb.
Aberlando Eco Chubb.
And
Sí,
Mr.
yo.
Ricardo, would you please introduce yourself to him, make sure he can see and hear you?
Señor Eco Chubb, mi nombre es Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí, te escucho.
He can hear me, Your Honor.
Great. Sir, I saw you this weekend for the charge of driving with no valid driver's license and set you a bond.
Señor, yo lo vi este fin de semana por el cargo de manejar sin licencia de conducir y le fijé una fianza.
You were brought back today to speak with an attorney to try to resolve the case.
Lo trajeron de vuelta hoy para que tratara de hablar con un abogado para que trate de resolver el caso.
I'm appointing the public defender's office to represent you, so please listen to your attorney, Mr. McDaniel.
Le estoy asignando la oficina del abogado de oficio para que lo represente, así que por favor escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Chubb. At this point in time, he's going to plead of no contest to the charges listed.
Su señoría, hablé con el señor Job. Él en este momento, él se va a declarar no me opongo ante los cargos, así como se le acusa.
Be sentenced to 3 days in the county jail, credit for 3 days, be a $400 fine, which will be a civil judgment.
Tendría 3 días en la cárcel de condena por los 3 días que ya ha cumplido y tendría una multa de $400 como un fallo civil.
Waived his right to a jury trial and call witnesses at that trial.
Ha renunciado a un juicio con un jurado y a llamar a testigos en dicho juicio.
Understands that any plea can be used against him in immigration court.
Entiende que cualquier tipo de acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
Understands that ICE has 48 hours to pick him up or he'll be released from jail.
Él entiende que Inmigración tiene 48 horas para recogerlo o si no, lo dejan salir de la cárcel.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Gracias, señor McDaniel. Y señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Eco Chubb, did you hear that agreement?
Señor Iko Chop, ¿escuchó usted ese acuerdo?
Sí, escuché todo.
Yes, I heard everything.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No, pues nomás tengo una pregunta si lo pago, será, pero ¿lo pago ese 400 o no? Porque yo tengo familia acá para pagar eso, pues nomás eso es lo que me falla pues con eso.
Your Honor, may the interpreter request clarification?
Yes, sir.
Señor, está preguntando si paga los $400 porque tiene familia o porque no tiene familia.
No, no tengo familia acá.
Okay. I was just wondering if the $400, if I need to pay that because I don't have any family here. So that was my one question about the $400.
My suggestion is wait and see what happens with the immigration case first.
Le sugiero que primero espere y vea lo que pasa con el caso de inmigración.
The clerk's office will wait 60 days, then they will send it to a collection agency if it's not paid.
La oficina de la Secretaría Judicial esperará 60 días y después lo manda a una agencia de colecciones en caso de que no lo pague.
But if it's not paid, all it does is, if it's not paid, it can affect your credit and it can cause driver's license issues. That's all.
En caso de que no lo pague, le afecta su crédito o le puede causar problemas con su licencia de conducir. Eso es todo.
In other words, you won't go to jail for not paying it.
En otras palabras, no lo llevan a la cárcel si no lo paga.
Do you have any other questions?
¿Tiene alguna otra pregunta?
Sí, pero si lo paga eso, ¿cómo voy a quedar, pues?
Your Honor, may the interpreter request clarification?
Yes.
Señor, ¿cuál es la pregunta?
O sea, si lo paga eso, ¿cómo voy a quedar con eso? ¿Me dejan salir aquí o cómo?
So if I were to pay that, would I be released here?
You have the immigration hold either way. You can pay it right now and you still have to wait on them to pick you up 48 hours like your attorney said.
Tiene la orden de retención de parte de inmigración. Aunque lo pagara en este momento, de todas maneras tiene que esperar 48 horas, como le dijo su abogado.
Okay.
Yeah, okay.
Yeah.
Have a good day, sir.
Que tenga buen día, señor.
Okay.
Did I impose the sentence? Mr. Ricardo, we have an add-on, sir. It's Martinez Gonzalez. It's the same charge. Driving no valid driver's license. He also has an immigration hold. Martinez Gonzalez. He's arrested from this weekend. If you'd please make sure that he can see and hear you, sir.
Señor Martínez González, quería verificar que usted me ve y me escucha como intérprete.
Sí.
He can hear me and see me, Your Honor.
Mr. Gonzalez, I saw you this weekend and posted and set you a bond for the charge of no valid driver's license.
Señor González, yo lo vi este fin de semana y le impuse una fianza por no tener licencia de conducir válida.
You're being brought back this morning to see if we can try to resolve that case.
Lo están trayendo de vuelta esta mañana para ver si podemos resolver ese caso.
I've also made you aware, I believe, that you have a hold from the United States Immigration Service.
Creo que también lo he puesto al corriente de que tiene una orden de retención de parte del Servicio de Inmigración.
Actually, I don't know that you were aware of that because I don't think you had this hold when I saw you this weekend.
De hecho, no sé si usted estaba al tanto porque no creo que todavía tuviera la orden de retención cuando yo lo vi este fin de semana.
Can you tell, is that correct, Lieutenant?
Y teniente, ¿me puede decir si es correcto? Si es correcto.
So you need to understand you do have a hold from the United States Immigration Service now.
Entonces, señor, debe entender que ahora tiene una orden de retención de parte de inmigración.
I'm appointing the public defender's office to represent you and asking that you listen to your attorney, Mr. McDaniel.
Le voy a asignar la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Gonzalez, is going to no contest to the charges listed.
Su señoría, hablé con el señor González, él se va a declarar no me opongo ante los cargos, así como se le acusa.
We sentenced to 2 days county jail, credit for 2 days.
Entiende que son 2 días en la cárcel del condado con crédito por 2 días.
Have a $400 fine, which we paid out of his cash bond that he paid.
Tendrá una multa de $400 que tendrá que pagar de la fianza en efectivo que él pagó.
Waived his right to a jury trial and call witnesses at that trial.
Ha renunciado a un juicio con un jurado y a llamar a testigos en dicho juicio.
He understands that any plea can be used against him in immigration court.
Él entiende que cualquier tipo de acuerdo se puede usar en su contra en el Tribunal de Inmigración.
He understands that ICE has 48 hours from when he bonded out to time they got to pick him up or he'll be released from the county jail.
Él entiende que Inmigración tiene 48 horas desde el momento que él salió bajo fianza para recogerlo o si no lo dejan salir.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Gracias, señor Mitchell. ¿Está de acuerdo el Estado? Lo está su señoría.
Mr. Gonzalez, did you hear that agreement?
Señor González, ¿escuchó usted ese acuerdo?
Sí, sí escuché.
Yes, I heard it.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
No, everything's fine.
And is that the plea you would like to enter?
¿Es ese el acuerdo que desea aceptar?
Pues sí, pues ya estamos aquí, ya. No sé qué puedo hacer.
Yeah, I mean, well, we're here now, so don't know what to do.
Well, if you enter this plea, you do not have to come back to court on this charge later.
Si acepta este acuerdo, no tiene que regresar al tribunal por este mismo cargo en el futuro.
But if you don't enter the plea, that's perfectly okay, but the case is not resolved and you have to come back to court later.
Si no acepta el acuerdo, está perfectamente bien, pero el caso no queda resuelto y tiene que regresar al tribunal en el futuro.
So would you like to resolve the case or not?
Entonces, ¿quiere resolver el caso o no?
Sí, pues.
Yeah,
Está bien.
Yeah, it's fine.
I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Voy a aceptar su declaración de no me opongo ante el cargo de conducir sin licencia de conducir válida.
Withhold adjudication of guilt and sentence you to 2 days in jail and give you credit for 2 days you've already served.
Le voy a suspender el fallo de culpabilidad y lo condeno a 2 días en la cárcel por los 2 días que ya ha cumplido.
Impose a fine of $400, which will be taken out of the cash bond you posted.
Le voy a imponer una multa de $400 que se le van a sacar de la fianza en efectivo que usted pagó.
And as Mr. McDaniel's already said, the immigration hold in your case, the 48 hours has already started.
Y como ya dijo el señor McDaniel, los 48 horas para inmigración en su caso ya comenzaron.
Do you have any questions?
¿Tiene alguna pregunta?
No. Está bien.
No. It's fine.
Have a good day, sir.
Que tenga buen día, señor.
Are you sure I imposed a sentence in Eco Chubb?
You did.
I did impose a sentence? I just don't remember it. Mr. Ricardo, thank you, sir.
Thank you, Your Honor.
Mr. McDaniel, we have at least one other person that has friends or family here, and that is Christie Graybill. Ms. Graybill, good morning. Your sister is in the courtroom, ma'am. Ms. Graybill, I saw you this weekend. First appeared you on the charge of driving under the influence, ma'am. You're being brought back this morning. You also have a hold from 7-day hold from Calhoun County violation of state probation. Ma'am, you're being brought back this morning to see if we can try to resolve your local DUI charge. Please listen to your attorney, Mr. McDaniel. I'm appointing that officer to represent you, ma'am.
Your Honor, I spoke with Ms. Graybill. She's going to plead no contest to the charges listed. Understanding she's going to be sentenced to 30 days in county jail, $1,078 in fines. She has 3 days jail credit. She has waived the right to a jury trial and call witnesses. That'll resolve this case today.
Thank you, Mr. Mitchell.
That is agreeable with the state, Your Honor.
And Mr. McDaniel, you want that normal language that you'd like? The plea can't be used against your language?
Yes, Your Honor.
Ms. Graybill, did you hear that agreement, ma'am?
Yes, sir.
You have any questions about that agreement?
No, sir.
And is that the plea you would like to enter to resolve this driving under the influence charge?
Yes.
Ma'am, I'm going to accept your plea of no contest to the charge of driving under the influence, ma'am. Adjudicate you guilty, find the plea is freely and voluntarily entered with the advice of counsel, sentence you to 30 days in jail, give you credit for 3 days you've already served, impose court costs and fines of $1,078. Ms. Graybill, you need to understand a couple things. Number one, Department of Highway Safety and Motor Vehicles in Florida will put additional conditions on you getting your driver's license back. They're going to make you do some things to get your driver's license back. You need to be aware of that. Number two, as part of this plea agreement, the plea can't be used against you in a violation of probation proceeding in Calhoun County. That doesn't mean they can't use the actual charge, the incident, what supposedly happened. It means you can't use what you're doing today. The entering this plea won't be used against you. If they do want to do that, I'll let you withdraw this plea. Ms. Graybill, ma'am, I was going to see you in 7 days. There's no need to do that now because you're going to be here longer than 7 days with this sentence imposed. But I do want the state to notify Calhoun County, and I don't know on the weekend. I'm assuming y'all probably got an email. They may have emailed probation directly. Mr. Van was the ASA this weekend, so he may have already emailed probation. But Mr. Mitchell, please make sure probation is or was notified of her new arrest.
We'll make sure.
Thank you, Mr. Graybill. Ms. Graybill, do you have any questions, ma'am?
No, sir.
Wish you the best, ma'am. Are y'all here for a first appearance case or here for a trial? Trial? Mr. McDaniel, that's it for friends or family in the courtroom. So we can go back to the top of our list. Eric Aguilar Villafane. Sir, good morning. You're here because you've been accused of 1 count of retail theft. This charge is filed as a felony charge. I've read the complaint. I think there's probable cause. I'm going to listen to Mr. McDaniel if he has anything to add. And then I also have looked at your criminal history, which is not good. So, Mr. McDaniel, anything on behalf of Mr. Aguilar?
Your Honor, I did read through the complaint. I did find some issues, with the felony charge. But with that being said, I don't see an issue as far as a crime being committed in a lawful arrest. I think there's different ways they could probably try to make it to a felony, but they haven't done that statutorily. If he was trying to manipulate some kind of security devices, they'd have to have more information in there about that. But at this point in time, we waive anything. We just ask for a bond. I don't know if he's going to be able to make a bond, but I told him the court date be August 4th, and we're just going to ask for a bond at this point, Your Honor.
Thank you, Mr. McDaniel. Mr. Mitchell?
We're fine with that, Your Honor. We just, we'll take the time to review it and see if it qualifies before the August 4th date.
I think you can use cumulative dates to add up to a grand theft. I just don't know if it's the exact same charge or if it's some kind of, it's a different charge. Mr. Gill, the allegations are 2 grand thefts on 2 consecutive, 2 thefts on 2 consecutive days. And they're adding them together to make 1 count of grand theft. And I think you can do that, but I don't know if it becomes organized scheme to defraud or if it's still considered grand theft.
I think that the period is 120 days. They can aggregate all thefts within there to get to the threshold of 750. But it does get complicated because sometimes it has to be 2 different places or the same place. But
does it the exact same statute number though?
Yes, it should be the retail theft.
Yeah, they did the regular grand theft statute. Yeah. Okay, so Mr. Aguilar, for first appearance purposes, we're going to find grand theft. Probable cause, sir. I'm going to set your bond based on your criminal history. Your bond $7,500 cash or surety. Sir, your bond has a condition to have no contact with any Walmart. You cannot go to any Walmart while this case is pending because you have a pending theft from Walmart. And you will use the phone in a few minutes, sir, to try to post the bond. If you post the bond, you'll be released immediately. If you don't post the bond, then the public defender's office will see you at the jail over the course of the next several days. And your court date, which you'll be given a notice for from the jail staff, will be August the 4th at 8:30. Do you have any questions, sir?
No, sir.
Wish you the best, sir. They use felony grand theft statute. No, they use felony retail theft statute. Next, we have Corey Jennings. Mr. Jennings, good morning. Mr. Jennings, you're here because you've been accused of 3 new charges. They are driving while licensed, suspended or revoked, knowingly tampering with evidence, and possession of methamphetamine. Mr. Jennings, there is probable cause for those 3 charges. The problem is it looks like you're already out on bond out of Jackson County. Is that right, Mr. Jennings?
Yes, sir.
All right, so Mr. Jennings, I'm going to set your bond in the new cases. Mr. Mitchell's estate asking this bond be revoked in the pending felony case.
Yes, Your Honor.
Mr. McDaniel, anything on behalf of Mr. Jennings?
No, Your Honor.
Mr. Mitchell?
Just the standard random UAs.
Thank you. So, Mr. Jennings, your bond in the new charges is going to be $10,000 each on the felony charges. That's the tampering and the meth charge. The driving offense will have a $5,000 bond. Your total bond in those 3 cases is $25,000 cash or surety with a condition of random urinalysis. Do not try to post the bond because you won't get out anyway. It'd be a waste of your money because I'm revoking your bond in case 25552 CF. That's the fleeing and looting. In the other case, you're already out on bond on. So, Mr. Jennings, you won't be released even if you post bond. You do have the right to contact friends or family or use the phone to tell them what's going on with your bond. And this should not change your court date. In other words, whatever court date you had previously set, you should still have in that other case. In the new case, the jail should give you a notice for August 4th at 8:30 to see if the state's had time to make a charging decision at that point. Mr. Jennings, do you have any questions?
No, sir.
Wish you the best, sir. Joseph Cogburn. Mr. Cogburn, good morning. Mr. Cogburn, I saw you this weekend. You had a no bond hold out of Bay County, a local charge of providing a false name misdemeanor. You've been brought back up this morning to see if we can resolve that case, that providing false name. I'm appointing the public defender's officer to represent you. Please listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Cogburn. We're going to plea of no contest to the charges listed. The understanding, he'll be sentenced to 90 days in county jail. You have 3 days jail credit, $370 fine. He has waived his right to a jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Cogburn, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, sir.
Is that the plea you would like to enter, sir?
Yes, sir.
Mr. Cogburn, I'm going to accept your plea of no contest to the charge of providing false name to law enforcement. Adjudicate you guilty of that offense, sentence you to 90 days in jail, impose a standard court costs and fines of $370 and give you credit for the time that you've already served, which is 3 days credit. Mr. Cogburn, what will happen, sir, is when you get near the completion of this sentence, the jail will contact Bay County and see if Bay County still wants you. If they do, they'll go ahead and send you down there. So you may actually finish this sentence while you're in the Bay County jail, but they won't let you go till you get near the completion. There's no probation involved in this sentence, Mr. Cogburn. And Mr. Cogburn, the case down there, it's not a VOP, is it?
No, sir.
All right, Mr. Cogburn, this resolves our charge here. Any questions, sir?
No, sir.
Wish you the best, Mr. Cogburn. We have Michael Estro. Mr. Estro, good morning. Mr. Estro, you were first appeared this weekend. Good morning. You were first appeared on the charge of petty theft this weekend, set a bond, brought back today to try to see if we can resolve it. Please listen to Mr. McDaniel, your attorney.
Your Honor, I've talked to Mr. Estro. We're going to plea of no contest to the charges listed. Petty theft, understanding to be placed on probation for 11 months, 29 days, $370 fine, restitution of $409.59. He's waived his right to a jury trial and call witnesses. This will resolve this case today.
So Mr. Goodson's questions is petty theft or retail theft? Let me go back and look at it. It's petty theft. That's what he's charged with. And there's a condition, no contact with any Walmart. Well, actually, it's a jail sentence. It really doesn't. Yeah, no, it's a probation sentence. So there's no contact with any Walmart. Also, Mr. Estro, be aware of that. Mr. Mitchell, anything from the state?
Did he say the restitution amount on there?
Did, $409.50.
No, nothing else from the state.
So, Mr. Estro, there is a condition, as I said, of no contact with any Walmart if you enter this plea. Knowing all of that, do you have any questions about the agreement?
No.
And sir, is this a plea you would like to enter?
Yes.
Mr. Estro, I'm going to accept your plea of no contest. I think this is the same plea that you were going to be made at that court date. I think you maybe said you didn't know about what you told me this weekend. So it's the same offer that was going to be made then. Accept your plea of no contest to the charge of petty theft, a misdemeanor in case 26-216 withhold adjudication of guilt. Sentence you to 11 months and 29 days probation. Standard conditions of probation, Mr. Estro, plus the following special conditions. Court costs and fines of $370, $409.59 restitution. The clerk's office does by statute charge $3.50 per payment. So you're better off paying that at one time if you can, rather than breaking it up, but you have the right to break it up. They just add a fee every time you do that. No contact with Walmart while you're on supervision. Mr. Estro, what's going to happen next, sir, is this. They're going to let you use the phone. Then they're going to let you get dressed. They're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because the courthouse is where the probation office is at. When you get here, you'll meet with the probation officer, and Mr. Goodson or Mr. Ham will go over the probation with you. And then once they go over everything with you, you'll be free to go. If you do call friends or family, you can tell them that she can be picked up at the courthouse about 30 or 45 minutes from now. I think there was a condition of retail theft school also in the plea offer from probation. Mr. McDaniel, was that part of the agreement also?
Remember, I didn't say anything to him, but
Yeah, it was on the arraignment offer. When I looked at Mr. Mitchell's arraignment offer.
That is what was on the original arraignment.
And it was in
offer.
my text also, so I think it just may got missed this morning. Is that what you were going to say?
no objection, John.
Okay, so there's going to be that condition of retail theft school. That's a standard condition. That was part of your original offer. So you still want to enter the plea, correct, sir?
Yeah.
All right. So everything I told you will be accurate. Do you have any questions?
Nope. I only.
All right. We'll see at the courthouse in about a half hour, sir.
Okay.
We have Marcus Peraza. Lieutenant, I did not get a chance to call because I was running out of time, but I got zero paperwork on Mr. Peraza this morning. I didn't get a face sheet. I didn't get anything. So I'm going to do a CCIS check.
So,
Mr. McDaniel,
we held him last week. We're going to bring him back today to see if Miami-Dade wanted to hold him for a probation violation in Miami-Dade. They have not filed anything. Nothing's been filed. So he's got a $35,000 bond. Locally, he's got a $1,500 bond for a driving offense in Bay County. So we just asked to release the hold for Dade County.
We did run him this morning, Judge, and there was no warrant active.
Thank you very much.
I don't even think they have the warrant active for Bay County, but that's not unusual. But there is a warrant in Bay County for a driving license suspended.
So what you're asking is to release the hold for Miami-Dade County. Okay, Mr. Mitchell, any objection to that?
Yeah, no objection to that.
I'm going to release that hold for Miami-Dade County. There's no warrant apparently, so that hold is being released. Mr. Peraza, you've got the bond set that your attorneys mentioned. Do you have any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
Good.
While we wait for the next contestant, Raul sent me $20 on Venmo. Thank you, Raul. His comment, it's Monday. Yes, indeed it is. Thank you, my friend.
They have court down there at 9 on Monday. What they got down there? All right. So, ladies and gentlemen, that concludes our first appearance docket for the morning, as far as I'm aware of. Mr. McDaniel, anything else from the Public Defender's Office? I think you're muted.
No, Your Honor.
Thank you. We've got Sergeant now switched on. Sergeant, anything else from the jail?
No, sir. That's everybody.
How was your?
Alrighty, friends, that brings to an end the first appearances for Wade Mercer. He's doing a jury selection right now. I've got my eye on that, and maybe we'll visit that. We'll see how the morning goes. Let's go back up to Huron County. New contestant in front of Judge Prill.
This time and date set for sentencing. The defendant is present, represented by Attorney Dallas L. Rooney. People are represented by the prosecuting attorney, Kenneth J. Rukowski. Back on May 18th of this year, the defendant pled no contest but mentally ill to assault with intent to great bodily harm by strangulation. Ms. Karen Everett has prepared the pre-sentence report dated June 29th of this year. Mr. Rooney, have you and your client had the opportunity to review the pre-sentence?
We have.
Any additions, deletions, corrections, or objections other than guidelines?
None to the report or the guidelines.
Do you agree with that, Mr. Lewis? Yes, Your Honor. Mr. Rakowski, any objection to the report as well as guidelines?
We have no objection to the guidelines or the report, but may we approach?
Yes. White noise, please. Also, for purposes of the record, the court received a document from Mr. Rooney on behalf of his client. This is a Huron Behavioral Health letter authored by Kimberly A. Lemke, Lemke, Master's Social Worker Limited License as well, regarding Mr. Nowinski. So the court reviewed that document as well. Mr. Rooney, anything you'd like to say on behalf of your client before the court imposes a sentence?
Yes, Your Honor. My client's 30 years old now. As you recall, the forensic center determined that he was mentally ill at the time of this incident. You probably saw from the forensic report and PSI, his upbringing was a bit unstable. Long history of juvenile placements, things like that. He has been involved in the mental health system since he was 9. It's a lifelong endeavor for a lot of people, like Mr. Nowinski. Although the letter that we did get from HVH indicated that he did complete successfully his recent outpatient services. He's been employed full-time at the local tiling company. He's been with them about 10 years. Working with them currently. He does have one son with joint custody. He did receive his high school diploma, notwithstanding the fact that he did have to have special ed for classes. As far as the $500 restitution for the damaged phone, because he's making pretty good money with his tiling company, he should be able to pay that relatively soon. In conclusion, I'm not going to get into the whole what all his various diagnoses were. You've seen all that in the various reports. But given that long, significant history of mental health issues and his psychiatric hospitalizations, and the fact that he was determined to be mentally ill when this event happened, we're asking to get no more than 1 year in Huron County Jail. We're asking to get work release since he is working now and he's been with the same employer almost 10 years. So he does need to get his paperwork done. Get his supervisor to sign it and pay the fee. So it's possible for him to work after work today, so we can get that paperwork done. I appreciate that. That's all I have.
Is your client wish to speak in light of the no contest?
He is not.
Mr. Rakowski, anything on behalf of the people? This is also a victim's rights case.
I don't know if the victim's here. See her. Your Honor, the pre-sentence investigation report contains all the information that's necessary. The parties had stipulated to a guideline range, which would involve the court considering county jail. And we just ask compassionate, fair, and just sentence, because I believe the guidelines should be. And I know the court asked us, that was the original guidelines, but Mr. Rooney and I had stipulated to the guideline range, and I thought it was 10 to 34 as habitual third.
Okay, very well. Thank you. This is a serious offense. There's no question about it. The problem though, and this was determined by the Center for Forensic Psychiatric Center for, how about Forensic Center? Probably easier to say. But there's no question, and this rarely happens, the center determined that the defendant was indeed mentally ill at the time of the offense. If you look at the history of the file relative to the defendant's mental health, it has been ongoing since age 9. At the time of the pre-sentence report, he's 30, so that's 21 years. Obviously, you need to be, how would I put it? The crime needs to be addressed, put it that way, number one. Number two is the mental health. And frankly, when you read this pre-sentence report and see what has been going on for all these years, it's astounding, frankly, the mental health aspect of this. And the court does have to consider that in fashioning an appropriate sentence in this matter. The court is aware of the stipulated guidelines that, frankly, the court is not bound by, but when you look at the mental health aspect of this, there's no question there's a serious issue regarding the mental health. And it's been treated, it'll need to continue to be treated, but at the end of the day, that's really, I think, the linchpin that puts you before this court today. Considering all that, it will be the sentence of this court that you pay restitution, the amount of $500 to Kendall, Craig, and Pat. You are to execute a wage assignment and pay that if you are employed and miss 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. Attorney fees are waived. However, there'll be a fine of $500 that will be imposed. $68 in state costs will be ordered as well. And finally, you shall serve 1 year in the county jail. Credit for 28 days previously served. You are to report to the jail after work today. What time does he get off for, Mr. Wood?
6:30.
Report to the jail at 6:30 to begin his sentence. I have no objection to PA 511 programming work release so long as he follows the Sheriff's Department guidelines. And the court is not going to order any probation in this matter. I do need to inform the defendant he has right to seek leave to appeal if he's financially able to provide counsel of his own choice. The court will assign counsel for him at public expense. He's to initially receive a questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days.
Initial the same.
Record shall reflect the same. Mr. Nowitzki, when you return or when you arrive at the jail at the end of the day today and every day thereafter that you have work release, they do test, so make sure you follow all the rules with that. Understand that? Good luck to you. I'll be on the record.
Hour 2 of TCF Live as we roll along. Let's go to Texas, Judge West.
Catherine Castillo.
This is you. Slide already done that.
Good morning, sir. Wayne Cummings. And this is 18-29640. Mr. Cummings has a motion to revoke his probation. And what is the announcement?
This is the one we're waiting on the charge to be filed in Orange County. It's still not been filed, Judge.
I feel like the last time we were here, I said we were going to have to.
I mean, we can proceed with the motion if you want to do it that way, but.
Well, I feel like we're going to have to at some point if they haven't even filed it yet.
Their intake is obviously backed up since when I was there.
So the motion, I mean, we've got a motion that was filed in December. So I feel like we need to go at some point, we need to just go forward with this. If something happens between now, if you want to, I mean, if y'all have an agreement, great. If not, we can go through the motion and I'll get, please, if true or not true, we can reset it for a hearing.
Yeah.
Just go through the motion.
Yes, please.
Mr. Cummings, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can put your hand down. And will your client waive the formal reading of the motion?
Sorry.
Mr. Cummings, in cause number 18-29640, I have a motion to revoke your community supervision. Shows that you were placed on probation October 22nd of 2018 for the second-degree felony offense of manslaughter, and that was a 10-year term in prison that was probated for 10 years. Is that correct? Yes. The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated October 5th of 2025 in Orange County. Is that true or not true? Not true. Count 2 alleges that you were at a location other than your residence at approximately 4:15 a.m. October 5th of 2025 when you were arrested by the Orange Police Department. And is that true or not true? Is it true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you were under the influence of alcohol October 5th of 2025. And is that true or not true?
Not true.
Count 4 alleges that you are behind in your court-assessed fees as of October 7th of 2025 in the amount of $4,909.47. And is that true or not true?
I've been paying.
That's okay. Did you enter your pleas of true to counts 2 and 4 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true?
Yes.
All right, I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for a hearing. I will set aside some time on a date when we're not in docket. If you're going to have somebody from Orange come over to prove it.
Probably do it at like 11 o'clock on the regular docket. Thank you, Judge. We'll entertain offers, obviously, with the hearing.
Okay, so here's the thing. I don't want him to get a police officer and witnesses lined up.
Today, Ron.
Do y'all want to talk today? Okay. So I'm going to hold it for now. Otherwise, I'm going to reset it for a hearing on the motion. If there's something that works out, let me know in a few minutes. If not, let me know so we can make sure and reset it. Okay? Yes, I need to update a PSI if they're going to.
On the side, for you. No, it's in Virginia. It's just, it's in the touch of you may have.
Let's see, Mr. Matthew Morian, you've got Carolyn Whitaker.
Yes, sir.
Good morning.
Good morning. How are you?
Good. Morning, Ms. French. Good morning. Good morning. You're Carolyn Whitaker. And Ms. Whitaker has 2 cases. They're set for trial to begin with jury selection next Monday. And what is the announcement?
We're ready, Your Honor.
State's ready, Your Honor. Anything that either of you feel like would need to be taken care of if it's number 1 before we get there next week as far as pretrial that we can't handle before jury selection?
Your Honor, I've been speaking with Ms. French about this. There's just some standard discovery motions and things like that. My notice is a request that I always request for orders to be signed on. Those are really the only things outstanding. The state has filed a First Amendment motion in limine last Thursday. I was unaware until this morning they filed that. Some of my staff have been out for a couple of days last week. And so I think the limines we can handle either by agreement. If there's any contestation, we do it that morning.
Perfect.
But just my standard, motion for disclosure with the 702 witnesses and the standard pretrial motions I filed, there's nothing crazy in any of those, and list of state's witnesses prior to trials, things like that. I would just ask for order to be signed on those.
Any issue?
No, Your Honor, we've discussed this and we had talked about working together this week to make sure that there's no objection to any of the motions so that we can make it pretty clean cut before the jury selected.
All right. Well, I would anticipate then signing all of those standard motions. And so just make sure you've got everything to give to him that you haven't already. I anticipate the case being fairly close to the top. If not, I will let you know tomorrow. I'll number the cases tomorrow after docket. So right after lunch tomorrow, you'll get a list. So Ms. Whitaker, stay in touch with Mr. Morian. He'll let you know when to be back, but I anticipate you need to be back next Monday at 1.
Thank you.
All right.
Appreciate
And I would remind the court that I will be out of town beginning August 2nd.
That's
The
right.
entire following week.
And is
So
this,
this is a case that can be tried the week of the 27th, without an issue.
no issue on
No
that?
issue.
Okay, perfect.
Now, Judge, I will say that we plan on there being any issues, but I tend to cause issues sometimes.
Well, as long as we can get, I mean,
Just,
it's very rare that we have any that go into a second week, but there's
Yeah.
one, I think, on the docket that
I understand.
Ms. French anticipates, but we'll handle your issues as they come up,
Thank you.
Mr. Morian.
Thank you.
All right, Ms. Whitaker, stay in touch with your attorney.
The only thing I want to bring to everybody's attention, and I know on these orders, on my standard orders that I filed, just to bring it to the court's attention and to the state's attention, I have some timelines on those. And so just depending on how, I just wanted to let y'all know before you'll start blank signing them, so you make sure to look at the timelines on when, because I always file them at the beginning of a case. So say, 30 days before trial or something like that. I just wanted to bring all y'all to.
Look
speed
at
on that,
these
so
real
y'all
quick
know.
because this motion for a copy of the jury panel criminal history record information.
And Your Honor,
don't have that.
the state doesn't have those documents and we're not required to create them.
Yeah,
So
I'm not
that
gonna,
would be-
I'm not
that's
gonna
something
order
we
that.
discussed this morning.
So that one, let's go through them then so you know real quick. So we've got a 702 motion for disclosure. Ms. French, any issue with that?
I don't think so.
Right, so I will sign that one. And then the copy of a jury panel criminal history, I'm going to deny that. Your motion for discovery and inspection, obviously that all should have been taken care of. Any issues specifically with that either of you have noted? Information that,
I don't think so. I don't think there's anything outstanding, Your Honor.
No.
right, so I'll sign that. And then motion for a list of state's witness, anything, any issue with that, Ms. French?
I thought I'd already sent it. I'm going to double check, and if I have not, that will be forwarded by this afternoon.
Perfect, I'll sign that. We've got a motion to limit the state's argument at punishment stage. I think we'll take that up when and if we get there. Motion to limit state's jury argument at the trial stage. What is that?
I was simply asking, it's one of those really neat defense motions, Judge, that asks the prosecutor's office to follow the law pretty much.
And as he and I discussed, unfortunately, I don't have one for defense, but if we're going to assume we're both going to.
That everybody's gonna do that, so no issue with me signing that, Ms.
No,
French?
Your Honor, that's fine.
Right, let's see, juries. And then we've got a notice of request for 3707, 3837, 404B, and 609F evidence. Any issue with that, Ms. French?
Not that I'm aware of, Your Honor.
I will sign that as well. I think that's what I've got.
And then we both have motions in limine, Your Honor. I think we'll take those up if we.
We can do that right before
Sounds
that
great.
morning. No issue with consolidating the cases. The state's filed a motion to consolidate.
No issue.
The state's filed a motion to accumulate. If there's a guilty in both, the state's already filed a notice of expert witnesses. Let's see what else I have here. Both of your motion eliminees, an application for community supervision has already been filed. The election for jury to assess punishment has been filed. All right, so I will sign, it looks like those 5 orders today, and then we'll take up anything else prior to jury election.
Thank you.
All right, thank you. You're free to go, ma'am.
Thank you, Your Honor. And I'm going to stay here. I'm going to stick in on one of my father's cases. He's going to haul over to Hardin County. We didn't know we were both in your court.
Oh,
today.
okay, perfect. So are you ready, or do you need a
I'm-
minute on Justin Edens?
I'm ready, Your Honor.
Justin Edens,
We live right across the pasture from each other and both drove.
y'all both drove here separately. Good morning, sir. You're Justin Edens. And this is 26 DCCR 0136. Mr. Edens is charged with making a false statement on property or credit. And what is the announcement?
Judge, this is one where Mr. Moran was here. We talked briefly. There's a couple of documents that he wasn't able to find I'm gonna have to go back and find them so that we can show submission dates and things.
Okay,
It's like 1 terabyte hard drive we got to cipher through. So if we just have one more reset, I think we can take it.
I'll just do a normal reset. Mr. Edens, about 30 days. Stay in touch with your attorney. Once he gets that information from Mr. Smith, you guys can go over it and we'll see if we can get an announcement at the next court date. All right, thank you.
Your Honor, may I have excuse?
Yes, sir.
Thank you. And that, and you said the court kind of let us know something tomorrow about
Tomorrow,
timing.
yeah, you'll get an email
Okay.
at usually right after the audit.
I've got my schedule blocked on this, just still playing. Thank you very
Perfect,
much.
thank you. Mr. Paget, you've got Catherine Castillo.
Yes, Your Honor, we're ready. Good morning.
Good morning.
On this one, she's pled to one of the cases and
Yeah.
reset it when it came up for sentencing because of the new DWI.
Speak up, please.
She's already pled to one. The other one has been filed now, so we're going to plead to that one. We already have the PSI, so we should be able to proceed with sentencing in both cases.
And so I've got 3 cases.
There's one that's being
Should be dismissed as part of that plea. Okay. All right, ma'am, you're Catherine Castillo?
Yes.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
And is there a new agreement because of that new case?
It's probation to run both. She's getting the same probation terms on both of the DWI's judge.
A 5-year term when she has a new DWI? So we're here on a DWI from October of 2024 for sentencing. And the reason we've been waiting was because there was a new DWI while that was pending from July of 2025. If I'm going to follow the agreement, it's going to be for a 10-year probation. I'm not going to agree to a 5-year probation when she was on bond and got another one.
Do you understand that? Yeah.
Okay. No, I don't, I'm okay, thank you. I don't, what I'd like to do though, also is get an updated PSI that has the information from that new offense so that I have all the facts of that and make sure that there is, because I don't have any information because it hadn't been filed yet. So let's do this. Let's go through the plea and then I'll reset both for sentencing. We'll get an updated PSI.
I have to have a probable cause if that was sufficient.
And we had the test results beforehand.
I saw that, yeah.
That's why we were, you were good enough to put out a little fire alarm there and got us to, we got the test results a little early.
I guess I want to make sure. That probation doesn't have any. One second. That they took that into consideration when making any recommendations for substance abuse issues and things like that. You know what I'm saying?
I do understand that. I was thinking that they did, but I'll. Look at the PSI's one.
But you look at what you do, want more than you said.
Yeah. So, Ms. Castillo, do you have the auto ignition interlock device on your vehicle?
Yes, I do.
What, if anything, have you done since July of 25 and that's last arrest and now for yourself and these issues?
I've looked into treatment programs because I are covered by the insurance, but I haven't.
You haven't done anything?
The only reason we had held up on that is because I wasn't sure what the probation department was going to recommend as far as treatment goes. She has full coverage insurance and she has checked into, in fact, I discussed that with Philip. There are some programs through her work, outpatient, intensive outpatient programs that are covered by her insurance.
It's been a year since your second arrest and your second wreck. Both of these were wrecks, one with another vehicle, one just you in a ditch. So are you working now?
Yes, ma'am.
Where?
With TIC and Port Arthur.
What are your hours?
I work Monday through Friday from 6 a.m. to 5:30.
How long have you been there?
Almost 3 years.
Full time?
Yes.
I mean, she's gonna have 20 days jail time that she has to do on these.
We were just hoping that she could, as long as she gives her work notice, work with her on that. We were just hoping that the court would be amenable to at least let her continue working while she does that.
Well, I mean, I'll do weekends when people are working. This gives me a lot of concern, but,
I understand, Your Honor.
all right, let's go through the plea first.
Speak up so she can hear you over there.
Okay.
All right, so will she waive the formal reading of the indictment in the new case?
First,
Okay,
the email in a second.
perfect, thank you.
She will, Your Honor. I apologize.
No, this is for the first one. They're emailing this one, second one. All right, Ms. Castillo, in cause number 26 DCCR 1177, it alleges that you committed the third-degree felony offense of driving while intoxicated with previous convictions, and that's from July 12th of 2025. The indictment alleges you were previously convicted of driving while intoxicated April 11th of 2013 and April 22nd of 2015. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
And are those two prior convictions true?
Yes.
I have here on the tablet some documents that have your signature on them, but this date's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison. There will be a $1,000 fine. The state's going to dismiss cause number 24 DCCR 2457, and then 2 misdemeanor cases, 24 CCCR 2921 and 2457. Also, you would be required to serve the 10-day jail sanction. The agreement in this that you guys have reached is for 5 years probation, but I've already said I'm not going to accept that. It's going to be a 10-year probation, or we're going to start all over. Do you understand that as well? And do you agree with me changing that to a 10-year probation?
Yes.
Which it's up to me anyway, how long the probation is. I usually will go along with that, but in this case, I think because we have 2, it's different. All right, so then do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tender number 1.
No objections to state's exhibit number 1.
It's admitted. Is there any evidence that Ms. Castillo is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and that you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, 3rd or more. And so with regard to going forward with sentencing, we have the pre-sentence report. It looks like this, they knew about this. They did some form of substance abuse evaluation. Is everyone okay with going forward without a new pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to the pre-sentence report that you guys got?
None, Your Honor. Not from space.
All right, so then in this case, which is 26-1177, again, I find you guilty. I'm going to follow the agreement that you made with the district attorney's office and sentence you to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay the $1,000 fine, and you're ordered to follow all of the rules and conditions of probation. That will include a 10-day jail sanction. We'll talk about that in a minute. It's also going to include entering and successfully completing the JCDI program, which is an intensive outpatient program, and any other rules and conditions of probation. It will obviously include keeping the auto ignition interlock device on your car. You cannot drive any car that does not have that device. Do you understand?
Yes.
All right, then in cause number 24 DCCR 2458, I'm going to find that you previously entered your plea of guilty in that case freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. Sentence you in that case in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. Again, I'm going to change that to 10-year probation in that case as well. You'll be ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. That will include the 10 days upfront time, JCDI program, and any other conditions that probation feels is necessary. Do you understand?
Yes.
And so with regard to that 20 days that you're going to have to serve, if you're working and you're working full time, then I'm okay with weekends. But if you want to do it all at one time and you have that kind of vacation, I'll do that as well. If you, in the next week or two, I can take that time off.
I don't have any vacation time, so.
So what I'm going to order then is that those 20 days are served starting this coming weekend. So you will report to the Jefferson County Jail every Friday for the next however many weekends it takes to get those 20 days. All right. So you'll report every Friday at 6 p.m. It's very important that you're not late. It's very important that you're not intoxicated. Some people think they're going to show up intoxicated and sleep it off over the weekend. It's a bad idea because it's a violation of your probation. You'll get out on Sunday and you'll do it you'll get 2 days credit. So you'll do 10 weekends in a row.
Okay, yeah,
What's that?
my son's birthday he's coming back from being with his dad for the summer, August 1st. Can I skip that weekend?
Where's it coming back from?
The valley.
It'd almost be easier probably just to start the weekend after, don't you think, Anna, for the jail?
Yes.
So, just so that it doesn't get confused or they don't think you're skipping because that's too much, for us to try to get anyway.
Okay.
Let's do this. Let's start on August the 7th.
Okay, thank you.
All right. And it'll be the 10 weekends starting August the 7th. All right. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. So if you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with Mr. Paget.
Okay.
So these opportunities that you're being given today, I want to make sure you understand these are great opportunities. And if you violate any condition of probation, coming back in and asking for some other treatment or something like that is most likely not going to happen. If you feel like you're having trouble and JCDI is not enough, then you need to make that realization and you need to talk to your probation officer and say you need more. Nobody wants to go do an inpatient treatment because they're going to be away from their family, but being away from your family for 90 days or so is a whole lot better than 10 years if you violate your probation. All right. So you need to have a seat here in the courtroom. Probation is going to call you up when she's ready to talk to you. Okay. Good luck.
Thank you.
And I'll sign that dismissal as soon as it comes through.
So interesting. 73% of you in the poll think that 10 years probation for a third offense drunk driving is a good sentence. I thought it would go the opposite way. That's interesting to me. But we'll leave the poll open for a few more minutes and you can continue to log your thoughts on that. Let's go across the hall, though. We'll say good morning to Judge Stevens.
Yeah, I'm looking at, it says MTRP is disposed of.
And
So this is what's left.
Yes, sir. So I had that one with Mr. Laird. So I just need to confirm with Mr. Laird.
Why are you pointing at me and calling me name?
Yeah, I know, right?
What are we doing?
My client recalls that with the MTRP that I was supposed to get rid of this case too, but what you said, yeah, I definitely, because the judge has already sentenced him on MTRP.
Okay. And I was supposed to.
Years.
He received 4 years. That's right, 4 years. Yeah.
And I agreed to get rid of an aggravated assault with a deadly weapon. I gotta look at that.
Take a look. I'm just.
Is it on paperwork? Did you look?
That's what he was telling me.
Let me look at it. Just give me a moment. A couple of moments, 15 minutes. What did you say?
Was the MTRP based on this event?
I think so. Reader, if I'm not mistaken, yes, sir. Yes, sir.
You need that list,
But I do remember the MTRP hearing, Judge. And I did remember you made a decision. I just couldn't remember the exact time.
What is house at the top?
I am right about there. And then while we waiting, I'm gonna sign up Sandy, that's a plea. I'm gonna get that done today.
Okay.
That's the next one you got, but I need to sign them up.
Which docket is it on?
That's same.
This
document.
announcement?
Announcement. Yeah, that's gonna be a plea. I'm gonna sign that one up as we speak.
Oh.
As we speak. But on this one, Mr. Booth, that was 4 years you did.
What was he on probation for? Do you remember?
For credit card fraud. Credit card fraud. Just the autopsy stuff you need.
So it had to be,
Fraud, Judge.
that's 4 years, so it was above a state jail felony, so he must have prior.
This is the one.
Most of those are state jail felony,
Yeah, this one.
unless there's prior conviction.
Okay.
What did y'all decide, Mike?
Judge, I'm showing I've already dismissed a robbery on him. I don't know what he's talking about this. I gotta look.
No,
at
this is aggravated.
I know. So I'm looking. Look.
It says, striking the victim about the head and body with a bike chain. Huh. And let's see, struck her in the right hand with a bicycle chain and stabbed her on the left side of her neck with a mail opener type knife. Was that the basis of the revocation? The allegation in the revocation?
Yes, sir, to my knowledge.
Judge, on the judgment, it says he pleaded true to count 5, which was, count 5 was a failure to report to the probation.
Y'all gotta be accurate with me. Because, I mean, we'll check it and
I'm looking, Judge, I hadn't
that
seen
wasn't
anything
the
with my
bad,
notes.
that wasn't the
anywhere.
ground that we revoked him for.
The police
So
papers.
we didn't revoke him for this allegation, this indictment. It's for administrative matter. Take your hat off, please. This is a court of honor. Thank you. While we're waiting, what about Cyrus Sandy?
I'm signing it up right now. That's a
Okay,
plea for certain.
Okay.
That's gonna be that's gonna be a plea.
Okay. What about Dan Shelton?
He is incompetent.
That
I'm sorry. Go ahead.
it was reset.
Oh, they reset it? Yeah, and I got a copy from this for you, Judge. Hold on one second. Let me get it to you. Give me one moment. On Dan Shelton.
Yeah, what about Shelton? Oh, he's got more than one, huh?
Right.
He's got two cases.
But here you go.
So it's the same thing.
Right, but here's for you. I think I got this for you. 1, 2.
You know what?
Here you go.
Did you pull those already?
Yes, sir.
Yeah, she pulled them. I don't have the files.
Right. Okay, but that was what that was is from Judge Holmes's court, the finding of incompetency. That was in 2025 in September from Dr. Chapon. That's on Shelton, Dan Shelton.
Yeah, but he didn't commit the crime until March 17th of 26. That's the key thing. He's finding in September of last year he was incompetent. That doesn't mean he didn't gain competency.
Yeah, but
when he committed the crime, I don't know. But I mean, it needs to be determined. The event was 6.5 a year later. So, I mean, they gain competency. You know that they can do it the next day or the next month. But did you want it?
I just want to get it to you for the file.
Is this for me?
Yeah, that's
all
for
right.
you. That's for you.
Anything we filled out for a plea agreement? I don't see anything we filled out for a plea agreement. On the MKRP. Did you do it? I'm not seeing any agreed plea on it. So glad to that.
Can you pull the MPRP data?
Judge, I'll have to go look and see if we still have the file. It's
Mike, can we come back to him?
over and done with.
Yes, yeah, we need to come back to him because I don't see any notes anywhere on anything that says we agreed to that. But nothing on the record. May have to get the lead out, whoever did the plea.
Okay, no problem. Just let me sign Mr. Sandy then. That's who you. That is a plea for certain. I'm gonna sign him up now.
Okay, just have a seat in the box there, sir. So,
and I'm
we can
signing up
figure this out
as we speak. Let me go get him.
David. And then
I'm signing up Sandy now.
What'd you say on Turner? David Turner. We got that one. That's an announcement. It's called family violence.
On him, can I have just one reset on him only? And I'm going to sign up Mr. Sandy now.
Hold on.
Yeah. You want to do what?
Yeah, he's filing out. He's filing motions on your behalf in this file. He's got a motion.
Representation.
Well, no, he's got a motion for Class A misdemeanor, state jail felon from the state jail felony. The only problem is this is third degree felony. It's going to be hard. It's going to be hard to reduce the third degree felony under 1244A. That doesn't work.
All right, friends, I'm going to keep an eye on this court, wait for them to rack up the next contestant. But in the meantime, let's keep with this channel's promise of 9 to 11% more Judge Boyd and head over to San Antonio.
How are you doing? Oh, I'm doing fine.
I'm Elliot.
Yes. All right, and your mom is on as well. Hi, if you could unmute, please.
Good morning.
Morning, how are you doing?
Oh, I'm so grateful for you and Ms. Sedovich's promptness in getting this case moved forward and hopefully getting Noel to a place where she can recover and heal.
All right. You're so welcome. I am sorry that this hasn't been done sooner. We're going to find out why it hasn't been accomplished, because I put certain dates for things, and my goal is to move people as quickly through the system as possible. And I will set things, and I understand when people have mental health issues, one, I want them to get the help that they need as quickly as possible, be moved out of the jail as quickly as possible. That is why I schedule things, because I want them to be successful, and I don't want everyone, please whisper. If you can't whisper, you need to stop talking. And I want them to be able to have the resources they need, because when they don't have the resources they need and they're out in public, sometimes they pick up new cases. So today,
absolutely, yeah.
So today I'm going to figure out why she's still in custody and why things have not taken place the way I asked that they be taking place. So just one moment.
I appreciate that very much. And I'm sorry that Noel is, a victim of the system here, unfortunately.
Yes. All righty. So who is the person who, because I ordered that, we're going to go on the record.
Judge, I'm going to bring both things.
Sure. All right, we're going on the record. The court is calling 2025 CR 007617, State versus Noel Luis Elliott. And are you Miss Elliott? Elliott?
Yes, sir.
All right, so this is the court's timeline. And if this timeline is incorrect, I need somebody to tell me it's incorrect. Okay. So according to my notes, you entered a plea in October 2025. I ordered that a TAP evaluation be done in custody. The reason why I ordered a TAP evaluation is because sometimes you cannot determine whether someone has a mental health issue if they have been taking controlled substances. So you have to get them clean and sober first. Then you can have an idea during the evaluation what the mental health issue is. So I ordered that. And I ordered a mental health evaluation to be completed at the same time. So that was completed November 10th, 2025, which that was pretty fast, because normally it takes longer than that, but I always say expedite, expedite, expedite. So then there was a recommendation for DDRF and Tacoma. And I signed that when that came in, and it takes Tacoma a while. So I signed that on December 2nd, 2025.
What is Tacoma?
It's they do an evaluation, but it ends up being inpatient treatment. It's to get you stabilized. All right, just 1 second. So trying to make sure the timeline was here. So the Tacoma was completed on January 22nd, 2026, which for them is very fast, right? Again, it was expedited. So then on March 9th, 2026, you sign your conditions for treatment, because you're like, you're correct. I need this treatment. I want this treatment. And so then those orders came to me once you sign it. I got it on March 10th. Now I don't leave the courtroom or the courthouse until I've signed every document that's presented to me that's in my folder. So I received it on March 10th. I signed it on March 10th. You were put on a wait list on March 19th. And here we are in July, and she's been sitting at the jail. And I don't think people realize the jail is not a safe place. And I'm probably going to get in trouble for saying this, but whatever. The jail is not a safe place. It's not a safe place for people who have mental health issues. The jail is not built to handle people with mental health issues. You're supposed to be trying to move people quickly through the system as possible. And when I order things and they're not done in a timely fashion, somebody could end up dying at the jail. Then guess what? Parents are upset. I'm upset. And I don't think that people are seeing people as people. I know people put a number on everything. Your social security number, that's how we identify you. Your SID number, that's how we identify you. But these are people. And people who are needing help, especially people with mental health issues. And when they are just sitting over at the jail, there are issues, there are due process issues. There are issues where legally someone can only be in jail as a condition of probation for a specific period of time. And when they go over that time, it's a violation of their rights. So somebody explain to me why she is still at the jail. Somebody explain to me why her uniform is dirty like it hasn't been washed. So please explain.
Okay, so Your Honor, the client had been waiting in jail since the allotted date that you stated because of there's a wait list normally for residential treatment, especially DDRF, due to the excessive amount of people that are required to be placed or waiting on a bed. There's an excessive wait list, and so she's been waiting for that long. However, there was a email sent out to me that the probationer had been experiencing barriers regarding her mental health and was not eligible to be transferred to treatment anymore. And so therefore we had sent an SR reporting it to you to basically advise you on what the situation was, as well as to maybe suggest or receive a suggestion on how we could move forward with pleasing the mother of the client, as well as the client, as well as treating her mental health, because right now she does not qualify due to how excessive her mental health has progressed.
I mean, her mental health is progressing the way it's progressing because people are not moving with a sense of urgency.
Yeah.
And because all of these deadlines that I've set have been missed. She's been in custody since October 2025.
Yeah.
That's unacceptable. Ms. Abrams, do you have any updates?
Judge, I mean, basically ran down the timeline I believe that I had. I think there was just a lapse in when the Tacoma was actually complete and possibly the moving forward with the packet to be sent.
Yeah, because the Tacoma was completed on January 22nd, 2026.
So I think that was your main concern when we spoke last week. So now we just need to figure out what.
So my thing is from January 2026, nothing was done. The Tacoma was completed. And then there were not orders sent to me until March 10th, and orders given to her till March 9th. I don't understand what the breakdown is in communication, but that needs to be solved because people die at the Bexar County Jail and they die at other jails and they're injured at the jails. And then guess what? People are asking me, why is this person still in custody? Why wasn't anything done from January 2022, January 22nd, 2026 to March 9th, 2026. There is no excuse for the gap from January to March. So somebody explain to me why there was a gap from the Tacoma completed on January 22nd, 2026. A jail visit is not completed with her till March 9th, 2026. And that's when she signed her conditions for treatment. Somebody explain that to me. Why is it takes that many months for her to get paperwork for her to sign?
And so whenever there is jail paperwork sent out, there's normally a wait list for that paperwork and signature. And when I had sent out the paperwork for the signatures and to explain to the probationer her conditions and that what she would be moving forward to do, there was a wait list. And so it had been set back for a week and a half. And then in order for me to speak to her, I had to be placed on a wait list for signatures. And so that was the process. And then
what is this wait list for signature business? I mean, do people not just go over to the jail? I mean,
no.
I mean, there's a 2 month, I mean, is this something that probation is doing? There's a 2 month wait to get somebody's signature on a piece of paper?
It was not 2 months. It was just about 2 weeks in order to get those paperwork signed.
No. According to this, Chacomie was completed on January 22nd, 2026. A jail visit with her for her to sign her conditions wasn't until March 9th, 2026. So I'm trying to figure out, there's a wait list for people to actually go over paperwork with somebody at the jail and get them to sign it?
Yes, Your Honor. There was a wait list. However, it was not 2 months, unfortunately. The wait list for it was, there was 2 weeks for the jail list. And then when the paperwork was received to explain the conditions, I had received a letter from Ms. Noel E explaining how she wanted to move forward. So I was reevaluating the case to see if I could assist in any other way. And then when the paperwork was sent for her to be signed, I know there were some questions in moving forward with the residential treatment. And so that was the holdup and the process, as well as the dates had changed for Takumi. And I was unaware of that till later.
All right, so here's the thing. Moving forward, there should not be this huge gap between Takumi being completed and then somebody in custody signing conditions. I could see if somebody's out of custody, maybe they're like, oh, I can't come in and sign. But this person is in custody and there's a wait list for documents to be signed and she has mental health issues. As far as I'm concerned, it seems to me people with mental health issues should be put at the top of the list because they have mental health issues and you're trying to get them stabilized as quickly as possible and get them moved to where they need to be to continue with their mental health treatment. So now the question becomes, one, I'm not going to keep her in custody for DDRF because that's going to be another 12 weeks. What is it, Ms. Abrams? 12 weeks, a year, what?
But right now, I believe it's 15 to 20 weeks.
It's 15 to 20 weeks. So I don't think that's right to do 15 or 20 weeks. Are you currently med compliant?
Yes, and I got probation back in October, and that's when I thought I would be getting out.
Well, no. You were not going to be released in October because of your mental health issues. I wanted to make sure there was a TAP evaluation done and a mental health evaluation done. So now the question becomes, where can she stay? And so it needs to be a place that can successfully help her with her mental health issues. So, Miss Elliott, is there any insurance or no?
No.
No, I'm a 70-year-old woman, a widow. Noel's dad died tragically when she was 17 in a single car crash. I survived now on Social Security only. Through the years, I did get Obamacare for her for a couple of years. She was in and out of 2 facilities that I can tell you about. One was Hannah's house down in South Padre Island. The other one, she went out to Florida but both of those places are mainly dealing with rehabilitation. And I don't believe that Noel's psychiatric and mental health issues have ever been addressed properly, nor has she ever been stabilized for any period of time.
All right, this is what we're going to do. We're going to take a short recess on this matter. I'm going to see if there is someone I can call to come over to see if we can find a placement for her. And we're going to get that done before the week is out, as far as finding a placement for her, okay? So
you're an angel. I'm telling you, I'm going to cry right now because
we're gonna do what we can do, and so my goal is to have her in a placement before the week is out. So let me make some phone calls. If there are no objections to my making some phone calls and seeing if I can find a placement for her, is that okay with everyone?
Yes.
All right. So just have a seat. Placement may not happen today, but I'm going to try to get her in a placement before the end of this week.
Okay, thank you.
Okay. All right. Thank you. All right.
I could be wrong, and time will tell. The new Judge Stephanie, who's going to replace her at the end of this year, may be something special, but I'm willing to bet that San Antonio is going to regret losing Judge Boyd. We shall see. Time will tell. I will keep an eye on this court. If it comes back while we are still live to this case, we'll go back to it. But as we move into hour 3 of TCF Live, let's detour back up to Michigan. Judge Prill has a new contestant.
6810, 226872, 226871, 236962, 236940, 236959, 236939, all FH. Time and date set for probation violation arraignment. The defendant is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Rakowski. Off the record, in front of everyone in the courtroom, the court inquired of Probation Department Mr. Nate Lick regarding the alleged number of technicals, number 1 and number 2, whether this is merely a 15-day maximum, and based upon what Mr. Lick had told the court, I believe there are 27 applications. So that's what he had stated, and as a result, it would not be a 15-day maximum. It would be the maximum under each of the respective counts. So, Mr. Rooney, do you wish to have the court read the request? Well, actually, let me read it into the record anyway. There's a request and warrant for probation violation in each of the respective files prepared by Mitchell Holtwick dated July 15, 2026. Count 1 alleges on or about July 14 of this year, the defendant failed to comply with written orders of the court. When it's alleged he was found in violation of Special Condition 4.9, which states he's not participating in gambling or gaming activities or entered gaming or gambling establishments unless first obtaining written permission from the field agent. It's alleged he is found to have entered a casino and participated in gambling activities. Count 2 alleges on or about the same date, July 14, 2026. The defendant was found to be in violation of Special Condition 8.1, stating he must pay restitution in the amount of $14,411.49 to Brent Mitchell. It's alleged he was found to have failed to make regularly scheduled payments. That's actually file number 6810. In 6872, alleges the same first count. Count 2 alleges July 14, 2026. The defendant was found in violation of restitution payments. $6,644.52 to Donna Wilson, $3,400 to Dave Pyle. When it's alleged he was found to fail to make the regularly scheduled payments. In 6871, count 1 is the same. Count 2 alleges unpaid restitution payments to Betty Champagne, the amount of $21,186. In 6962, it's alleged Mr. Backus violated count 1 only. In 6940 FH, the same. In 6959, the same. And in 6963, count 1 is the same, but count 2 alleges unpaid restitution payments, $72,773.47. Roel Mendoza Ackerman, OCOMEN, that restitution amount $15,072.80. Jeffrey Scott Martin, $1,725. Timothy Shooting, $4,233.31. Mark McLeod, $4,482.35. Jeanette Haig, $2,195. Deborah Woodward, $6,800. Lori Funk, $1,400. T1 Credit Union, $7,400. Moore Shoreline, $399. Edwin Eichler, $28,826.50. Village of Elkton, this is file number 2354 SM, $238.76. Further alleges per the plea agreement, defendant is to pay restitution in all charged and uncharged files. It's alleged he failed to, again, make regularly scheduled payments. Mr. Backus, do you understand all the allegations made against you? Yes. You're entitled to a full probation violation hearing where it must be determined by preponderance of the evidence. In other words, more likely than not, we violated the terms and conditions of your probation. You're entitled to beside the assistance of counsel to the hearing, disclosure of all the evidence against you, a right to confront and cross-examine all witnesses against you, a right to provide testimony and witnesses if you wish to. The court can compel witnesses to testify in the event they're not willing to come forward on your behalf. You're presumed, I'm sorry, let me strike that. You have the right to remain silent. Your silence cannot be used against you. You have the right to testify subject to cross-examination by the people. You understand all those rights, sir?
Yes, sir.
All right. Mr. Rooney, how does your client, oh, wait, just a moment. We have to go through the maximum sentence that we impose. In 6810, based upon the alleged number of technicals, the maximum sentence the court can impose would be up to 5 years minus any time served to date. In 6872, maximum of 5 years minus any time served to date. In 6871 FH, five years minus any time served to date. 6962 FH. Again, 5 years minus any time served to date. 6940 FH. Years minus any time served to date. 6959 FH. 14 years minus any time served to date. 6939. 5 years minus any time served to date. Understand this? Mr. Rooney, how did your client wish to proceed?
Well, Your Honor, I've given him copies of the pictures of him in the casino and other documentation, so he will admit that he's gone to the casino on a number of occasions, which is against his probation conditions. And I think he would agree that he still owes significant amounts of restitution on these various cases. And since he was laid off in March from Michigan Sugar, he was not making regular schedules.
That's all files, correct?
Yes.
Mr. Backus, as best you can, would you please raise your right.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I did. Sir, your name is Edwin Joseph Backus. Yes. Mr. Backus, do you understand everything that's going on here, sir? And you understand the maximum sentence that can be imposed on each of the respective files? Have you had sufficient time to speak to Mr. Rooney about this?
Yes.
And do you need any additional time to speak with him? Anything affecting your mind or brain making it difficult to make important decisions? You have a clear mind?
Somewhat.
Okay, is there a problem?
I have a mental health issues, but it's not like that. Just I have a lot of depression.
All right, but you understand what's going on here today?
Yes, I understand.
And you're making you're making your own decision after speaking with your attorney and thinking about it.
Yes, yes, okay.
All right. How do you plead to these allegations? The court takes judicial notice of its prior records, which indicate that as conditions of probation, defendant is not to be in these types of establishments. You acknowledge that, correct?
Yes.
You were in these establishments?
Yes.
Gambling?
Yes, I was.
How much money are we talking about?
I'm not exactly sure.
A lot of money?
I significant.
And you knew that was wrong?
Yes.
Why?
I'm panicked. I've been trying to curb everything. I did good for a while, and then I had a lot of trauma and going through a lot. Mentally, physically, medically.
Any objection to the factual basis, Mr. Ricard?
No, Your Honor.
Court will accept the plea. It's done freely. It's voluntary, understanding, and accurate. Anyone threaten you to enter this plea, sir?
No.
Is your own free choice?
Yes, sir.
Plea will be accepted. There's a sufficient factual basis. A sentencing date. Set it up for August 31st. Any objection? Sentencing August 31, 2026 at 9 a.m. Court's ordering updated probation violation report be prepared, provided to both counsel and the court at least 2 days prior to sentencing. Is there a bond currently? Oh, there's no bond. This is the right. Yeah, the recommendation. I've asked the court for some sort of cash bond and a curfew monitoring tether. He's only allowed to be released from his home for verified medical and blood. Mr. Rakowski, your position on that?
Your Honor, we would agree with Agent Lick that the recommended amount that people would have, and since there's a significant amount of restitution, $20,000 cash.
Well, the amount that Mr. Rakowski proposes is not feasible. You can probably raise a somewhat low bond, and the reason I would argue for a lower bond is that when the security people at the casino confronted him, he went out and called his probation agent right away. He got back to town, I think, the next day or so. Probation officer told him to go report to the Pigeon Police Department, which he did right away. And I believe he's done the paperwork to self-exclude himself from the casino. He's lived in our county for 24 years. I've got paperwork that he's expected to go back to work August 5th. Michigan Sugar, although he tells me that he recently was diagnosed with some colon cancer. So I think if he had the tether, he would be able to do that and go to work. But I don't think of much beyond a couple $100 bond feasible, but I'll leave that up to you. Mr. Rakowski.
Just, I would say in response, just that the court, I'm sure, is very familiar with this, but there were several of these victims, elderly victims, that, $5,000, $2,000 that they've expended, and we don't have any restitution being paid, and yet he's at the casino. And so that's why we're asking for the higher amount. I mean, a citizen turned him in because they saw him going up to the casino.
Court is consider MCR 6.106. What got him here was the gambling, frankly. And how do you speak to victims when they hear this? Be difficult. I'm not, obviously he's under a plea, so the court can state that. But frankly speaking, there's so much restitution involved. The court agrees with Mr. Rakowski. Plus, the defendant indicated that he's an addict relative to these activities. And okay, so he is prohibited from entering casinos, violated that rule. He self-reports saying he will no longer be able to go. But what's stopping him, in this case, is very familiar with lottery tickets and all the other gaming activities that are going on. I think $20,000 cash surety is an appropriate bond. The court is going to order that bond in this matter. And if it's posted, the defendant is to be placed with a GPS monitoring device. And as Mr. Lake stated, either for medical or employment only. Curfew monitoring. It's called curfew monitoring. Okay. That'll be on each file.
Alrighty, friends, hour 3 of TCF Live on this Monday. Let's go back to Texas. Judge Stevens, new contestant.
I'm going to get it first. 23 CR 138 called. The state of Texas versus Gary Michael McWilliams. That's you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary? Yes, sir. In summary, this indictment alleges that on or about May 21st, 2023 in Jefferson County, Texas, you committed the state jail felony of theft of material, and it looks like it's copper. Do you understand what you're charged with here?
Yes, sir, I do.
Absolutely. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 1 year in the state jail. Is that your understanding of the plan?
Yes, sir, it is.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
They got caught at the scene, so they didn't, the people didn't lose their stuff, right? Everybody?
They caught him in the act.
Okay. If I follow this agreement, you have no right of appeal and you will be given credit for all time you've served in accordance with this case.
Yes.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived
Yeah,
here.
sure.
I will follow this agreement. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of theft of material, namely copper. And following this agreement, you were hereby sentenced to confinement in state jail for 1 year. Do you understand what has happened today, sir?
Yes, sir.
Okay. Is there anything else you have pending?
No, sir.
Okay. All right.
Thank you.
I have Christopher Salinas.
Going back.
Oh, boy. Ran out of blue ink. I'm completely out of blue ink. What's this? Nope, I got one.
Salinas,
Go over in front of that lady, thank you.
raise your right hand for me. You swear or affirm to the truth and nothing but the truth of God. Okay, independent right thumb print, your whole thumb print. Place it
Both the whole
flat
thumb
on the
print.
box right here. Okay,
Okay.
get it one more time. Place it flat right there. Okay, and you go stand by the judge.
Okay. We now call 23 CR 1792, the state of Texas versus Christopher Salinas. Present. Here, present. Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about July 10th, 2023 in Jefferson County, Texas, you committed the state jail felony of criminal mischief. Let's see. It says intentionally and knowingly damaging or destroying tangible property, namely a chain fence, by cutting the fence with wire cutters. And that was the loss of $2,500 or more, but less than $30,000. That constitutes a state jail felony. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can also be assessed. Do you understand the punishment range? An agreement has been reached where you would be pleading guilty, sentenced to 2 years in the state jail. Then that would be suspended. You would be placed on regular probation.
Judge, there's also restitution.
For up to 5 years. Yeah, I hadn't even got to that part, but I don't see how much rest. And it says restitution, but there's nothing filled in.
We showed $9,549.
Oh, let me try to work this device here. But is the eraser. All right, once again, it's how much?
$9,549.
Restitution equals $9,549, and that would go to the victim in this case, as alleged in the indictment. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign it? Understand it? Discuss it with your attorney. The contents all true and correct? State's Exhibit 1 entered into evidence. Without objection, it's submitted. This states that you are mentally competent to enter your guilty plea freely and voluntarily. And if you know what you've been charged with, Ms. McNally, you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. This is part of the record for purposes. Pre-sentence report is waived. I'm going to follow this agreement. One thing I want to ask is, you're going to be ordered to pay back restitution, the loss, in the amount of $9,549. How are you going to do that?
I gotta find a job.
When was the last time you had a job?
Back
Years?
No, it was,
You're homeless though, aren't you?
I was living with my girlfriend. I had a job. I was a home care provider for a friend's daughter. I'm gonna see if I could get that job again.
Okay. Are you a licensed home
No, sir. It was a friend's daughter. She was sick. I was just washing the clothes or maintaining the house.
What do you have a skill for?
I'm a great handyman. I was working out in the oil fields. I just need
Well, what were you making then? An hour? A lot, probably.
22, 27.
I was going to say 30 at least, but man, okay. Well, that's 50 grand.
Yeah, I could get that job again. It's because ever since I lost my vehicle, I've just been doing bad. I've been trying to stay up, but it's just, everything just kept falling down on me, and I'm still happy. Like, that's one thing my life hasn't
Well, let me
done.
just give you a word of advice is your story of life isn't really much different than ours. I mean, we got good days and bad days.
Yes, sir. Yes, sir.
And it's like 2 steps forward and 1 step back in everybody's life.
Yeah, mine was like 10 steps back and 1 step forward.
Well, why was that?
Ever since my childhood, I've had a rough life.
Welcome to planet Earth.
Yeah.
Everybody's got a story.
Yes, sir.
I wish I was. Yeah, I wasn't born in a millionaire's home, and
yeah, yes, sir.
We're that kid. But anyway, the point is that your story is not much different than probably most people. The point is, this is fixable, but you got to fix it.
Yes, sir.
How many criminal convictions do you have?
Just the one on the top of my head.
Fix that.
Yes, sir.
It's
Do
weird,
better.
it's weird, it's like,
No.
it happened when I was 17, it happened when I was 27.
Well, I know, but the 17,
It's like a 10-year.
you've gone through 12 years of schooling. Come on.
Yes, sir.
You know, we make choices.
Yes, sir.
We make good choices and bad choices. When we make a good choice, we reward it. Bad choices, we get punished. And we really, from what I take it here, from looking at this, you're smart enough guy. You're wise enough to know right from wrong and what is the best choice and what isn't. Fix this.
Yes.
Move on with your life, get the trade. And if you get into the oil, business, out there, I mean, you're going to make a lot of money and you'll be able to then do good things.
Yes, sir.
With it.
Yes.
Rather than bad things.
Okay. You don't.
I keep finding you, but I don't seem to know that. Anything else to add by anybody? So again, there is sufficient evidence supporting this guilty plea to find you guilty beyond a reasonable doubt, and I find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. You do well, fix this, pay this back. It will be shortened in 1/3.
Okay.
Which is a year and 2/3.
Okay.
18 months. Essentially 18 months, 18 to 20 months. You must pay restitution in the amount of $9,549 to the victim complainant, as that name is here in the indictment. If you fail, your probation could be revoked and you can be sentenced up to 2 years. How much time does he have?
I could have at least 5 months back time.
Yeah, you would know better than anybody.
Yes, sir.
Because I'm sure you don't forget that.
Yeah.
Nobody ever does in this room who's going through it. But you don't want 24 months.
Yeah, I don't.
Fix it, move on, make a life that's independent and that is of doing good things.
Yes, sir.
Anything else? That is all. Good luck. You're going to see the probation office. He's going to go over all those terms, you sign it, and you can move on.
Alrighty, friends, last half hour now of TCF Live. Today is flying by. Let's step across the hall. Judge West.
Good morning. Morning, Smompino. Morning. Sir, are you Michael Harrison Jr.?
Yes, ma'am.
And this is 25 DCCR 1859. Mr. Harrison is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, we've received discovery, reviewed it with my client. I received an offer from Ms. Malfino. If you would allow 30 days for a plea setting, the case will be disposed of.
All right, we'll just do a normal reset for a plea. Mr. Harrison, make sure you stay in touch with Mr. Paget between now and then. Y'all can go over everything and we'll get that taken care of at the next court date. All right, thank you.
Michael.
Would you mark down plea for her and Michael Harrison with Mr. Paget, please?
And Judge, just to let you know, my officer Moss on that continued hearing on Jabari and Guillory, set for 11.
Okay.
He's here already. If I
Okay.
might just have a few minutes with him, but when we finish this, we'll be ready whenever.
Okay, thank you.
I have another sentencing.
Sarah Kennedy, Mr. Paget's the sentencing.
Well, I've already filled out the discovery certification, but there is the.
Thank you very much. Here's the attachment for this case on Mr. Paget's, Kennedy. Good morning, ma'am. You are Sarah Kennedy? Yes, ma'am. And Ms. Kennedy was previously here in clause number 25 DCCR 1463, entered a plea of guilty to the second-degree felony offense of assault on a peace officer. I've received that pre-sentence report. Any additions or corrections?
None from the defense, Your Honor.
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, found guilty, so you would have the conviction, and I could sentence you to prison anywhere in the punishment range, which is between 2 years and up to 20 years in prison.
I have a question. So with my dad, he's disabled vet, and sometimes I have to become like say to Houston.
Just, you can get permission from probation. So you're not allowed to leave Jefferson County without permission. So if you have an appointment coming up, all you need to do is talk to them, get them whatever they ask for with regard to that. And that should not be an issue as long as everything else is going well. The main thing is to ask for permission first. Don't go and then say, well, I went, because if you get pulled over for a traffic ticket or something and we find out, then you're going to be here on a motion to revoke for something that's not that serious. Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed. So you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you.
May I have excuse?
Yes, sir.
Thank you.
See.
I know you will. Y'all have a it's all Dennis the other day. And I guess he'll be happy when he does. Yeah.
Alrighty, we'll keep an eye, but let's go back across the hall again to Judge Stevens because he has somebody.
Fair enough.
So 26 CR 410 is called the State of Texas versus Cyrus Sandy. You're Mr. Sandy.
Yes, ma'am. I mean, yes, sir.
Yeah. Generally, they don't mistake me for a girl. That would be, but you had it narrowed between one or the other, and it was a 50-50 shot that you had. You're here with Langston Adams,
yes,
who is your attorney.
Yes, sir.
And does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
I see we got two paragraphs here with an enhancement. Are we passing on the enhancement part?
We are, Judge.
Okay. In summary, this indictment in paragraph 1 alleges that on or about March 2nd, 2025 in Jefferson County, Texas, committed a 3rd-degree felony of fraudulent use or possession of identifying information or items, which is in a number of more than 5 but less than 10 pieces of identifying information. And these are credit card numbers and debit card numbers. And that was without the consent of the people whose names were there on those items and without their permission. So this is a 3rd-degree felony, which means you're looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreement's been reached in your case where you would be pleading guilty, sentenced to 7 years in prison. Then another case, 25 CR 1443, would be dismissed. Is that your understanding of the agreement?
Yes, sir.
I'm gonna write a 7 in here too, the numerical 7, just so that there's not a problem with it. Okay, 7 years confinement. And the other case will be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Is there any restitution?
I don't believe so, Judge, but let me check for the process.
No, we have not received any claims, John.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it?
Yes, sir.
Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
And without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to be appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I will follow the agreement and find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony, fraudulent use or possession of identifying information, items, we got to correct the indictment here of the caption. It's got items less than 5, but more than 10, which arithmetically can't happen. Correct it. It's in the caption, so it's not part of the body, but it's still wrong. Yes, it's good. In the body, it's correct. All right, that's been corrected. There is sufficient evidence supporting this to find you guilty beyond a reasonable doubt of this third-degree felony. I now find you guilty beyond a reasonable doubt of this crime. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. Then you will, of course, be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
All right, that is all.
That's it. Thank you. Appreciate it. Good look, Lord. All right, take it easy. Mr. Falls. Ms. Moore.
Yeah, I've got David Booth and David Turner still left.
I thought he was gonna reset Turner on Booth.
Yeah.
He's adamant saying that he didn't do that. But I want to bring him out so you can hear. Let me get Mr.
Wait. One thing at a time.
You wasn't. Oh.
Well, let's let them sort out what they're doing. I want to go back up to Michigan and Judge Prill. Whoever's in front of him now is in a turtle suit. Always fun. Let's see what that's all about.
People of the state of Michigan versus Lucas Paul Davidson, first file 267422 FH, time and date set for sentencing in that file. 267423 FH, status conference, and 237028 probation violation versus Davidson. Present, represented by Attorney Michael A. Morosky. People are represented by Prosecuting Attorney Timothy J. Rakowski. Oh, I'm sorry, I didn't even look. Assistant Prosecuting Attorney Alexander Pahani. I apologize. Pahani. All right. In the 7422 file, defendant entered a no contest plea to resisting obstructing a police officer, 2 counts, as well as the probation violation sentencing. Dated plea June 29th. Mr. Nate Lick prepared the pre-sentence report dated July 9, 2026. and actually the pre-sentence report, I should say the probation violation report is dated July 6th. Mr. Morosky, you and your client had the opportunity to review both reports.
Mr. Davidson and I did review both reports, Your Honor.
Any additions, deletions, corrections, or objections to either report?
No, Your Honor.
Any objection to storing the guidelines in the way described?
No objection to storing the guidelines.
Mr. Davidson, do you agree with all that?
Sir.
Mr. Mahoney, any objection to the report as well as guidelines?
No objection from the people, Your Honor.
Thank you. Mr. Morosky, anything you'd like to say on behalf of your client before the court imposes?
Yes, Your Honor. Mr. Davidson and I did review both PSIs. Your Honor, there is a mental health component here that Mr. Davidson has been dealing with mental health struggles. You know, that's very well documented. Mr. Davidson has been hospitalized many times for, suicidal ideations. He has suffered from mental health conditions. Now, he continues to work on his mental health. He's worked with HBH, and it seems that his medications are now proper and he's being properly medicated. Mr. Davidson is deeply remorseful for what had occurred. He's had time to reflect on his actions and wants to be a productive member of society. Mr. Davidson is a young man who has dealt with past trauma regarding his childhood, and he wants to continue to work on that to become a better person. In regards to the file number 26307-422-FH, the guidelines here are 5 months to 34 months. The MDOC is recommending a sentence of 2 years, 3 months to 4 years, Your Honor, with 273 days served. In that file, we would ask for 1 year in the county jail and a term of probation, so Mr. Davidson can prove that he can be a productive member of society. In regards to the probation violation, it's directly related to the RNO case that we're adjudicating now. We asked for a sentence, that he be discharged unsuccessfully from probation, and time served, Your Honor. Thank you.
You're welcome. Does your client wish to address the court in light of the no contest?
At this time, he does, Your Honor.
Go ahead, sir. What would you like to tell them?
I take full responsibility for what I've done. I regret my wrongdoing while incarcerated. I've done a 180 while incarcerated. I've changed my behavior and thinking into something positive. I don't want it. Plan on going back to the old me. I'm eager to work on managing my emotions more effectively and learning how to cope with stress and frustration in healthier ways. I'm asking for an alternative sentencing like outside therapy or anger management classes. I don't take lightly the opportunity to request this alternative sentencing. We fully recognize the gravity of my past actions and the impact they had on others, and I'm sorry and promise to do better. Also, I wrote a list of the things I've accomplished while being in jail. While in jail, I've gotten closer to Jesus. Sorry.
You need not apologize.
I pray every night. I read my Bible every night. I started looking at people more. I changed my way of thinking, wrote sincere apology letters, meditated more, found inner peace, rebuilt broken relationships, found self-worth, and learned patience and learned effective communication skills. And my goals when I get out, my plan when I get out is to get back on disability, pay fines and restitutions, take care of my grandma, preach the gospel, go to church every Sunday, do 3 community services, help the church out, attend therapy, get GED, and get my own place and get off paper. That's all I have, Your Honor. I'm sorry.
Don't need to apologize. Mr. Tahani, anything to be asked of the people? This is a victim's rights case as well.
It is, Your Honor, and the defendant makes an argument here that's simply not supported by his actual behavior. If the court reads in the pre-sentence report, his behavior while an inmate in the Huron County Jail has been simply abysmal. The substance of some of those reports is truly disgusting, Your Honor, and for to listen to the defendant stand here and tell you that he's turned his life around while incarcerated in the Huron County Jail, I think any of the corrections officers standing in this courtroom would beg to differ. The defendant has an extensive felonious history and this extensive assaultive history, is not accepted treatment from Huron Behavioral Health, to the point where at one point in this case, when they were supportive of assisting him in mental health treatment, they ultimately withdrew their services because he wouldn't cooperate. Your Honor, the only thing that's going to offer any sort of change for Mr. Davidson is a term of incarceration in the Michigan Department of Corrections. That's what the people are asking for at the top of the 34-month guideline. Perhaps the programs that are available for him in the DOC will be more effective than what's been offered to him locally.
One of the victims in this case is Lieutenant Newman.
I believe so, Your Honor.
Question regarding the probation file. Is he on the registry?
Yes.
Okay. Thank you. Well, there is a mental health component to this, and the court has to consider that. And the court,
Your Honor, I don't mean to interrupt, Your Honor, but regarding Huron Behavioral Health, Mr. Davidson was cooperating with them, and then they ran out of services they could provide. It wasn't that Mr. Davidson ignored them or wasn't trying to work with them. He was trying to, work with them, but there was no more services that could be offered.
all right, thank you. All right, the guideline range in the newest file is 5 to 34. Obviously, the guidelines don't apply relative to the probation violation file, but the maximum is 2 years. And under People versus Milburn, 2/3 of the maximum is the only thing the court would impose. And so, to anyone who may be out there about, well, he didn't or she didn't get 2 years in prison on a 2-year offense, well, there's case law that prohibits the court from sentencing that high. You can go to a maximum of 2 years, but you can't give a 2-year sentence right out of the gate. And as to the probation violation file in this case, the defendant has served 665 days. And again, on a 2-year maximum. 2/3 of the maximum of 365 times 2 would be 486 days. So relative, if I have my math correct. So defendant is unsuccessfully discharged from probation relative to the probation violation file. He is to serve, or will order 13 months, 2 years. Credit for 665 days already served. All outstanding fines and monetary obligations remain collectible, which means that you're not going to prison on this file because you've already served beyond the maximum. So even though it's a prison term, with your credit, you won't have any further time to serve on this case. Unsuccessfully discharged from probation. Regarding the police officer resisting obstructing 2 counts of habitual offender third, as stated, the guideline range is 5 to 34 months. And the court does have to consider the mental health history. The court has done so. But the court had an opportunity to see the defendant with the prior 5. And when reading the pre-sentence report, certainly there are mental health aspects of this, but there's also the aspect of actual volitional behaviors of the defendant that indicate he's acting out, and not necessarily because of mental health issues. So considering that, the court finds that the recommendation is appropriate. It will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 2 years and 3 months, 4 years, with credit for 273 days served, which is below the maximum guideline. Crime victims assessment of $130 be ordered. Attorney fees are waived. $136 in state costs will be ordered. Due date on all those attached.
September 14th.
September 14, 2026, then the 20% fee will be imposed. It's my duty to inform the defendant he has right to seek leave to appeal if he's financially unable to provide counsel of his own choice. Court will assign counsel form of public expenses to initial receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Which file? 7422. Credit for 273 days. 270. Honey, what's the status of 7423?
I believe, Your Honor, the people will file an Noel E pursuant to the plea agreement.
Very well. Good luck to you, Mr. Davidson. I wish you the best. Love you.
Alrighty, friends, before we call it a day, I'm going to go back to Judge Boyd's court. A few minutes ago, that defendant from earlier where Judge Boyd was trying to find her a placement or whatever, she came back. So we're going to watch that real quick. And you'll notice that the person standing next to her has changed. So that's interesting to me.
Okay. And so your mom is going to Zoom back in, or either Miss Abrams is going to contact her. Let her know. We're going to call you back on Thursday. We now have a plan. It's going to be done as quickly as possible. You're going to follow through on your part so that we can get our part done, okay? So here's the thing. I'm putting you on the docket for Thursday. If they have an interview with you for a placement on Thursday, they're not going to bring you over because I don't want to interfere with that, okay? But we're the 23rd, so I can see what's going on, okay? So that's Thursday. So today is Monday, Tuesday, Wednesday, Thursday. We're going to see where we are with you.
Yes.
At the latest, they're telling me they'll have placement for you next week, but it may be sooner, okay? So you're going to be compliant with your medication, and then we're going to move on, okay?
Okay, okay, thank you.
You're welcome. So 23rd, the plan is, and I want you to, I'm saying this over and over because I want you to be aware, okay? On Thursday, they're going to let me know where we are in the process. If they are interviewing you or they have something they need to do with you, they're not going to bring you over because I don't want to stop the process. And at the latest, you will be in placement, not this week, but next week. So one step at a time, okay? You do your part, I'm going to do my part. All right, thank you. Thank you so much for coming down.
Thank you, Judge.
Take your medication. Thank you, Honor.
You're welcome.
I'm just here because
Oh, no, I appreciate you coming in.
you see, when I talked to her and tell her, I said, you need to take your medication. I've known Noel for a long time, so.
Yeah.
Okay, thank you, Honor.
All right, thank you so much. Oh, and Miss Abrams, if you have her mom's phone number, can you get it to?
I'll give it to.
Oh, or either you can call her.
Alrighty, friends. Lindsay, thank you for $20 for TCF overtime. A short overtime today, but thank you all the same. But I wanted to make sure that we caught what happened at the end of that. So it sounds like she's going to come back maybe Thursday, if I heard that right. So perhaps we keep an eye out, but it looks like they've found her something, or they're at least close to finding her something. So thank you all so much for spending your time with me this morning. It has been fun. You'll see me later today on In the Blind with Mike and Dan. This stream will redirect over there when it's done, so you can set a reminder for that. And of course, we'll be back tomorrow morning for TCF Live, 9 a.m. Eastern, 6 a.m. Pacific. The wisdom I leave you with today: integrity is choosing courage over comfort, what's right over what's fun, and self-responsibility over blame. I really like that one, and I hope you guys appreciate it too. Again, I will see you later today over at In the Blind with Mike and Dan, and see you back here tomorrow morning. Take care. God bless.